SDPB celebrates South Dakota's student athletes with live coverage of SDHSAA state championships, sharing the excitement of hometown heroes. SDPB, good, useful, and full of wonder. From choir to debate to theater, SDPB shines a spotlight on South Dakota's talented students through SDHSAA All-State Fine Arts Programming. Good, useful, and full of wonder. SDPB.
Good morning, everybody. Welcome back to House State Affairs. We will now come to order. I'd ask everybody to please take a seat. Have your phones turned to silent. If you plan on testifying today, you have to sign in the back, and the pages will help you. Use the iPad. It's all electronically now. If you're a lobbyist, please wear your badge and make sure the badge is clearly visible. If you're joining us online, the email address is housestateaffairs@sdlegislature.gov. If you're wearing a hat today, we ask that you remove it if you come up to testify. And I would remind everyone that all testimony and all questions are to be addressed through the chair so we can maintain order. At this time, I would ask the secretary to please call the roll.
Representative Baumüller.
Here.
Emery. Here. Gosh. Here. Healy.
Here.
Heineman. Here. Jameson.
Here.
Lems.
Here.
Reich.
Here.
Schaefbauer excused. Soy excused. Overwig.
Here.
Otenbach.
Here.
We have a quorum.
Thank you, Madam Secretary. We do have a quorum. At this, 1 minute.
Sorry.
Would you like to call
Representative Hanson.
I'm here. Hey, everybody.
The chair will take note that Representative Hanson is in fact here. Okay, at this time, the chair will entertain a motion to approve the minutes of our last meeting.
I'll move that motion.
Motion by Overwig, seconded by Gosh. Those in favor of approving the minutes would please say aye. Aye. Those opposed, no. The minutes are approved. Okay, at this time, I'd ask the pages to come up to the microphone and please briefly introduce yourself, state where you're from, and mention any future plans.
Hi, I'm Taryn Torsney. I'm from Tyndall, South Dakota, and I just signed on to the Army National Guard. Do you have any fun questions for us?
Yeah, you don't even want to start with that. We don't have enough time to go down that route today.
Dang
so,
it.
Yeah.
Good morning, I'm Maria Stephenson. I'm from Arlington High School, and I plan to go to SDSU to either get a math major or be somewhere in the health department.
Excellent. Thank you both for being here. Okay, our agenda this morning is going to keep us busy. We're going to have to keep things moving. We have 4 bills. We're going to switch it up a bit from what was published. We're going to take 1275 first and then go in order for the rest of them. We're going to do 10 minutes each side just because that's the time constraints we live under. If you're the proponent, please plan accordingly. If you take up 9 minutes and then have 8 people who all want to talk after you, well, that could be a problem. So the first item, is there any other matters for the committee? Any personal privileges or anything else before we jump in? Okay, then we will start off today's agenda with House Bill 1275, create requirements for age verification and parental consent for application stores and to provide a penalty therefore. Proponent testimony, please.
Mr. Chair.
Good morning.
Good morning, members of the committee. My name is John Hughes. I am State Representative for District 13. I am the prime sponsor of HB 1275. I do have an amendment, which is 1275C. It has been published, and I would appreciate a motion.
Sir.
I move that motion.
Motion by Overwig, second by Gosh to move 1275C. Is there any discussion on that motion? Is it published? Hang on. We're all looking diligently. We see 1275A, but we do not see C. Are you sure it isn't A? It does say Hughes, and it says 1275A.
I could be confused. Where is okay, we're good. We're good. Thank you. Sorry for the confusion.
So just to restate, the motion by Overwig, seconded by Gosh, is to move 1275A. Is there any discussion on the motion? Okay, seeing none, those in favor of the motion to amend will say aye. Aye. Those opposed, no. Motion carries. We are now on 1275A. Please proceed.
Thank you, Mr. Chair. John Hughes, State Representative, District 13. We have several excellent subject matter experts here, so I will be brief. Briefly put, HB 1275 gives parents of minor children a simple private way to keep their kids safer online. It establishes guardrails at the digital gateway. App stores already control age ratings and payment systems. This legislation is supported by a vast array of child advocacy organizations that are committed to creating and maintaining a safer digital space for our children. 4 main points. Minors are protected by requiring parental permission before they can agree to an app's terms of service. They're minors after all, they can't contract in South Dakota. Requires app stores to verify age using available data and technology. Requires accurate app age ratings to ensure parents give their informed consent. And we're focusing on contract law, not content moderation or free speech. So I will stand by for questions. Thank you.
Thank you. Any other proponent testimony?
Mr. Chair, members of the committee, Grant Flynn with the South Dakota Attorney General's Office. We too rise in support of this bill. We appreciate Representative Hughes and the other sponsors of this legislation cooperating with us to ensure that we can, that the Attorney General's Office can enforce the law in the broadest sense that we are able, and they worked with us to ensure that there was language in the bill that would allow us to do that both under state and federal statutes. So we appreciate that cooperation, as the Attorney General's Office has done in the past. We too rise in support of the protections that exist in this bill to protect children on the internet. These are important common sense regulations that require parents to know about and approve of what their kids are doing on their phone, and we think that just makes sense. Thank you.
Thank you. Any other proponent testimony?
Good morning, Mr. Chair, members of the committee. I am Lisa Gennaro. I'm with Concerned Women for America, and I sit with the West River Human Trafficking Task Force. What I see is this. We teach our kids to try and be responsible online, but that shouldn't be their only safeguard. Platforms that expose minors to adult content and high-risk features should take responsible steps to verify age. This is about shared responsibility and a basic protection for children. I focus on prevention. The next person, Mr. Chair, we would like Holly Strand, who is online, to come up next. We work together on the task force, and I think she'll give you some more insight. Thank you.
Very good. We will jump to Holly Strand online. Miss Strand, can you hear us?
I can. Good morning, Chair, members of the committee. My name is Holly Strand. Today I'm testifying as a private citizen. However, for the last 10 years, I've worked for the Pennington County Sheriff's Office, assigned to the Internet Crimes Against Children Task Force. I want to take a second and remind everybody back about 2 decades ago when our phones didn't come with a flashlight application. People had to go to the App Store and download a flashlight application. There were several to choose from, but the one that caught security experts was the one that required all permissions in order to use the flashlight. People gave away all of their data for a flashlight application. We worried about our parents, our grandparents, and our less techie friends, but we didn't worry about our kids because kids didn't have phones. Now, fast forward, our kids do have phones, and they're making these same decisions. They're falling traps for the same deceptive practices and dangerous practices. They're allowed to install applications without asking about the risk. They're agreeing to give away their personal pictures, their personal videos, their private messages, which may be used against them in college interviews or job interviews. They're sharing their location to every predator out there without understanding that it's giving their fine specific location. They're also downloading applications which give permission for their microphone and camera, which could secretly record them, knowing that they're giving that permission. They also may feel compelled to download applications which circumvent a parent's ability to monitor their kids. What we also know is offenders will encourage kids to download Kik, Discord, Snapchat in order to easily exploit kids and also reduce the odds of getting caught. What we know is kids should not be in this position to look at the permissions and determine whether they're safe and whether they're willing to give all that data away. I'm going to leave with this. I heard a wise doctor once say that when we fight over kids having access to technology, it's like we're arguing over the safest way to give our kids arsenic when we should be asking if we should be giving our kids arsenic in the first place. I know this bill won't do everything, but it's a great step in the right direction. Thank you.
Thank you. Any other proponents in the room?
Mr. Chair, members of the committee, thank you for having me. My name is Melissa McKay, and I'm the president of the Digital Childhood Institute and the policy director for the Child First Policy Center. I'm a device and online safety expert with almost a decade of experience. I've worked on about a dozen online child safety bills, spearheaded 3 national safety movements, and written extensive FTC complaints against Apple and Google. The App Store Accountability Act, this bill, is one of my favorite bills. It's endorsed by 170 of the most prestigious child safety groups across the country. It's very simple, elegant, and basically only requires 3 things. First, it requires centralized age verification at the App Store level. This approach is far safer and more privacy-preserving than forcing 800,000 individual developers to collect and store age data themselves. Jonathan Haidt supports a similar model in his book, The Anxious Generation. Second, it requires parental consent for every app download and in-app purchase. These downloads involve lengthy terms of service contracts that exploit children and their data. A parent should always be the one who consents to legally binding contracts in behalf of their children. Third, it requires accurate app age ratings and clear disclosures. Right now, a high percentage of apps misrepresent their content, privacy policy, and age ratings. Parents cannot make informed decisions if the information they are given is unreliable. I hope you will take the time to read this myths versus facts sheet. There's a lot of misrepresentations floating around about this bill. I'm sure that you are going to hear some of them today. This bill has passed nearly unanimously in 4 states, and we hope that it'll pass in many more. Thank you.
Thank you, Ms. McKay. Other proponents?
Morning, Mr. Chair. Norman Woods, Family Voice Action. I want to briefly talk about just the history of this issue, but then also the history of this legislation specifically. So the history of the issue, this is a question actually as old as time, because Adam and Eve were the first people to agree to Apple's terms and service without really understanding what would happen. But I'm channeling my inner David Owen. But the history of this bill. So last year we came before this body, we asked for similar legislation, and at that time we were essentially asking you, hey, will you run this experiment with us? No state has done this, Utah's working with it, should we try it? You know, the legislature wasn't comfortable stepping out as the first. Well, now there's 4 states. While we were crafting this legislation, there was the Texas injunction. We can kind of go into why that was bogus reasoning, but we crafted the bill in light of it anyways. Just a few days ago, there was another lawsuit in Utah. Again, we think it was kind of bogus reasoning, but we crafted this bill in light of that anyways, just a few days ago, making tweaks. So Alabama recently passed this unanimously, so now there's 4 states. We're no longer going to be the guinea pig. We can learn from those other states that have passed it, so that's what's before you today. Thank you.
Thank you. Couple minutes left. Any other proponents?
Good morning, Mr. Chair, members of the committee. Rachel Foltz, Call to Freedom Director of Impact and Program Relations. We echo all of the testimony and sentiment thus far. Call to Freedom is a South Dakota nonprofit dedicated to serving those impacted by human trafficking and commercial sexual exploitation. As the digital landscape grows and evolves, traffickers and bad actors are increasingly using digital technology, including mobile apps, to recruit, exploit, groom, and abuse children. We strongly support House Bill 1275 because of its incredible potential to prevent digital crimes against children by mandating parental consent before a child can download an app. We firmly believe that children should be prohibited from entering into legally binding contracts that have serious safety implications. Parents alone must dictate whether and how their children engage in digital spaces, and they deserve the right to review and sign contracts on their behalf. Call to Freedom's youth case manager has one of the highest caseloads on our team, and the volume of tech abuse cases is staggering and growing. I strongly urge a yes vote on House Bill 1275 today for the sake of my team and much more importantly for the hundreds and hundreds of child victims that we represent. Thank you, and I'll stand by for questions.
Thank you, Ms. Foltz. 30 seconds left, so a couple quick comments and some Me Too's.
Good morning, Mr. Chairman, members of the committee. Michael Pauley with the South Dakota Catholic Conference. Just here for a Me Too. Urge you to support House Bill 1275. Thank you.
Thank you, Mr. Pauley. Any other final Me Too's in the room or online? Okay, seeing none, then we will turn to opponent testimony. Any opponents here in the room?
Mr. Chair, committee members, Doug Abraham, a lobbyist for ACT, the App Association, also a lobbyist for the Motion Picture Association, who submitted a letter that details their position. I'd ask you to reference that as well. Well, we heard a lot there. I would say not a lot of substance, and I think most of it's pretty easily rebutted. So I want to start first with what this bill actually does, and I'd ask you to direct your attention to Section 3 of the bill. It says an app store provider, at the time an individual who's located in this state creates an account with the application store provider on or before December 1st, 2027, the effective date, must request an age category information from the individual and verify the individual's age category using commercially available methods that are reasonably designed to ensure accuracy or an age verification method that complies with this chapter. So what's that mean? Effectively, it means everyone who uses a smartphone will have to give their state-issued ID to verify their age to big tech. If you have concerns about Real ID, if you have concerns about your personal identifying information getting out there into the internet nether, this is the bill for you because it's going to force you, if you want to use your iPhone or you want to use your Android-based device, to do that, even though you're 18, even though you're a consenting adult. We already have a lot of problems out there in the world with seniors being taken advantage of. Now, if they're going to go and get onto their healthcare app, if they're going to check the news, any of those things, they're going to provide their state-issued ID to big tech to verify their age. And more than anything, it is for a purpose that's already covered by the app stores. So Google, Apple already have parent controls that can allow you to lock down a phone. I have an 11-year-old and I have a 14-year-old. They both have iPhones. They cannot download a single app without me first getting a text that says what the app is they're seeking, what the age rating for it is, and gives me a link so that I can check out what the app actually does. We already have controls in place for parents to do this. This is legislating parenting at its worst, frankly, because it protects the bad actors. This isn't about protecting kids. This is about shifting the burden from the bad actor apps to the app stores who don't produce content. At what cost? Significant cost to both the app developers and the app stores. But who does it protect? It protects some of the apps that have already been sued in various states. You know, you heard the history of this, and I want to correct that because that's not really an accurate history of where this bill came from. 2024, there was a summer study. A version of this bill was provided to the Attorney General's office by Meta's lobbyist. It was then introduced as one of 3 options. It was rejected during that summer study, and it was rejected again last year. So I'd submit, we know where it came from, and we know who it protects. And it's an effort to protect bad actors. When you look at a big picture standpoint, the best analogy I've heard of this is if you had a liquor store in a mall, and you're trying to prevent kids from going in the liquor store, this bill requires everybody who enters the mall to get carded. We think it's a better idea to go ahead and card those people that are going into the liquor store. And that's not what this bill does. Just want to talk briefly, because we're relatively short on time, but the contractual aspect of it, 18-year-olds or 18 and under minors in South Dakota can't enter into legally binding contracts. That's the law today. We don't need a bill to say that. That's already the law. So that's a bit of a red herring. Beyond that, I would say, when I talk about the bad actors that this shifts the burden from, I'd ask you, go out, I know you all have devices, Google actions by state attorney generals against Meta, Instagram, and entities like TikTok. You'll find they're replete with them. And that's the reason for bills like this, is because it shifts the burden. It doesn't really protect kids. Parents have to protect kids. We have given, and tech companies have given tools to parents to protect kids, but you have to avail yourself of it. Even if this bill passes, if parents aren't going to actively parent, kids are going to get jailbreak phones. They're going to be able to access all the harmful content anyways. We need to be more parent-centric and make sure that we're using the tools that we already have. So I encourage your opposition. I'll certainly stand by for any questions you may have. The last thing I would say, I handed out to everyone, it's an injunction. That's the Texas injunction. This has already been found to be more likely than not unconstitutional in Texas. That's not bogus. That's a federal district court judge. I'm not going to impugn the integrity of a federal district court judge. It's very solid reasoning, and I encourage you to take a look at it. Thank you.
Thank you, Mr. Abraham. We're 5.5 minutes in. Any other opponents?
Good morning, Mr. Chairman, members of the committee. Nathan Sanderson, I'm the Executive Director of the South Dakota Retailers Association, rising in opposition to House Bill 1275. There is nothing I would like better than to not be here this morning. Retail businesses are caught in the middle of what has been, for the last number of years, this ongoing push and pull between large tech companies. Our guys just want to sell stuff. They want the government out of their business. They want to pay low taxes. They want to have reasonable regulations, and they don't want to get in the middle of this. But against their desires, they are in the middle. How are retail businesses in the middle of this? If you sell something online with this bill, and the customer that you're working with right now has an application that they utilize to purchase your goods, every retailer is going to have to push pause on that until those customers upload a real ID. That's what the bill does. For obvious reasons, retailers oppose that approach, and we'd encourage your opposition to the bill.
Thank you. Any other opponents? Okay, moving to online. Do we have online opponents? Oh, one more. Sorry, sir. We see you now.
Can you hear me? Good early morning. I'm Corey Marshall, Senior Director of State and Local Public Policy at the Chamber of Progress, here in respectful opposition. Hope you all are having a wonderful morning. Chamber of Progress is a tech industry coalition working to shape a future where innovation uplifts everyone and access to technology is universal. As written, HB 1275 would require app stores to verify the identity and age of all users, a tremendous encroachment on individual privacy. And here's the irony. Verifying someone's age actually requires collecting more data, not less. I know the members of this committee are fervent supporters of protecting children, and as a dad of a baby boy, I truly am as well. But this bill is not the vehicle to get there. It would absolve some companies of their shared responsibility to protect children online while placing the burden on the shoulders of just a few. 2, app developers are better positioned to implement tailored safety measures. They understand their users and specific risks that their platforms present. South Dakota has an opportunity to set a precedent other states will want to follow. People across this country do look to South Dakota's leadership, and that means getting this right. Florida and Mississippi are two bright red states, the state of my father, examined App Store age verification mandates, and they rejected them. Alabama moved forward and is now headed straight to court. This could cost, if this bill moves forward and is signed by the governor, taxpayers in South Dakota at least $1 million or more in lawyer attorney's fees. A federal judge in Texas blocked that state's version just last December, finding it likely unconstitutional. Utah passed a similar law and is already facing a First Amendment lawsuit filed this month. So I'd encourage this body to not move forward with this bill. It's a bad bill, and to wait and see how this plays out in court so that you also don't end up there. As a federal judge in California noted, it's always funny when I hear people say that we borrowed this age verification laws from the United Kingdom. She said that in the UK doesn't have the First Amendment, and in America, we do. And that's not just a detail, it's a right that we must protect. For these reasons, we urge you to oppose HB 1275 respectfully. Thank you.
Thank you, sir. Got about 30 seconds left and a bunch of people. 5 in the room, I'm told, and 4 online still. So we're down to Me Too's. Basically, state your name, who you're with, and very briefly, Me Too.
Yes, thank you, committee. My name is John Tamney. I'm president of the Parkview Institute, a policy think tank in Washington, D.C. I urge you to vote against HB 1275 precisely because many of you are parents and you know the difficulties of parenting. It cannot be reduced to a law. Secondly, as already has been stated, Apple and Google and their devices arm parents in myriad ways well beyond the law to protect their kids. And so the law is superfluous and while well-intentioned, which leads to the biggest problem with it, precisely because most parents don't need it. The very few will look at the law and say, well, we're already protected. We don't need to be vigilant about our kids because the law is looking after us, and that leads to the peril of it. And so I realize the time is limited, but I respectfully urge you, because you love the children of South Dakota, to vote against HB 1275.
Thank you, sir. We were effectively out of time, but want to give everybody a chance to state who you're with and give a Me Too.
Good morning, Mr. Chair, members of the committee. My name is Samantha Chapman. I represent the ACLU of South Dakota, and I would associate my comments with the previous speakers. Please oppose this bill. Thank you.
Thank you. Any other opponents? Okay, and online, first up is Heather Andrews, just to give a introduction and a Me Too.
Well, thank you, Chair. I'm Heather Andrews. I'm a mother of 4 and grandmother. Just want to say this bill will not protect South Dakota children, as stated. It's no surprise that companies such as Pornhub and Grindr have supported legislation modeled on this approach. I really urge you today to vote against House Bill 1275. Thank you.
Thank you. Next up, David McGarry, introduction and a Me Too.
Good morning. My name is David McGarry. I'm the research director at the Taxpayers Protection Alliance. I associate myself with most of the things that have been said in opposition today, and for the privacy and constitutional reasons, I urge you to oppose the bill.
Thank you, sir. Next up, Amy Boz. Introduce yourself, give a Me Too.
Good morning, Amy Boss, Vice President of NetChoice, a trade association dedicated to free expression and free enterprise online. We respectfully oppose HB 1275 due to the privacy and constitutional concerns.
Thank you. And final is Caden Rosenbaum. Please introduce yourself and give a brief Me Too.
Thank you, Mr. Chair and members of this committee. My name is Caden Rosenbaum. I'm Managing Director of Tech Policy at Reason Foundation. We provide pro bono policy consulting to policymakers and stakeholders in this area of technology reform. We respectfully oppose this bill and ask the committee to consider age attestation methods rather than age verification, and stand by to advise as the committee sees fit. Thank you.
Thank you. I believe that ends our opponent testimony unless I see anyone else in the room. So with that, we will give the prime a chance for a rebuttal, a brief rebuttal.
Okay, back up again. My name is Melissa McKay. I'm the president of the Digital Childhood Institute, and I have been waiting my whole life to rebuttal Apple in a hearing. So thank you for this opportunity. First, and most importantly, this bill does not require like a digital government ID. Commercially reasonable means would usually mean if you're an adult, the credit card you already have in your digital wallet. If you're a child, parent attestation of their child's age. So this whole idea that this is cumbersome or invasive is false. I mean, and when you're signing contracts, when was the last time you went to a title company and they said, well, we don't want to have you show your ID, so just go ahead and sign the contract. We're just going to let this go. So that's kind of what the opposition is arguing for, is ageless, faceless contracting, which, you know, it's kind of been the Wild West in the App Store for 15 years, and probably time to bring it into what everybody else is doing in the real world. Second, they argue that this legislation is unnecessary because of parental controls. I have brought with you the guide to set up iPhone parental controls here. They sell this online for $30. It's 80 pages long, 330 screenshots, and does not cover even like the thousands of loopholes that are in these parental controls. Last month, my youngest son just turned 13. He got an email from Google with very explicit instructions on how to remove parental controls. Google considers 13-year-olds adults. I wrote a post about it. It went viral, got 3 million views, and Google stopped doing that because of my post, not because they wanted to. Apple also treats 13-year-olds like adults. So to pretend that this would cover laws and regulation is false. Finally, I'm going to talk briefly about the Texas injunction, because that seems to be one of the key talking points of the opposition. Texas added 2 exceptions to their law. They added an exception for 911 apps and an exception for SAT education apps. Because of those exceptions, the liberal court, which also enjoined the age verification for porn websites, same court, they said, oh, this is a content-based bill, strict scrutiny, we're going to enjoin this law. The South Dakota law, we wrote it with no exceptions, and we also took every other little thing that we could find in that law. If they said, oh, this is too vague, or you know, this needs to be crafted a little differently, and we tightened it up. Same thing with the Utah lawsuit. I mean, most of it we did feel like was bogus, but we tightened it up again. So the bill that you have before you today is different than any of the other laws. It's the best version, the tightest version, and we hope you'll support it.
Thank you. With that, we'll close the taking of public testimony and open it up to questions from the committee. Any questions from the committee? Okay. Then if there aren't any committee questions, I will open it up to, do you have a question, Rep. Heineman?
Yes.
Go ahead, sir.
Leader, for Mr. Abraham.
Go ahead.
Somebody's got to start off here. Thank you, Mr. Chair. I think part of your testimony indicated that lawsuits will abound, that states, I think you cited all 5 states are involved in it right now, or there's an injunction in Texas. I guess my question to you is, so you don't think that fighting for our children's future is worth going to court for? So we as legislators should not go that route. Is that correct?
Mr. Chair.
Mr. Abraham.
Doug Abraham, attorney from Peoria, registered lobbyist for ACT and the Motion Picture Association. Representative Heineman, no, I would say that couldn't be further from the truth. I would say protecting entities like Meta, which is what this bill does, this is not fighting for your kids. This is state-based parenting and substituting state action for parents' actions. Parents are already enabled with the tools to protect their children today. This bill doesn't further that. What it does is it drags every South Dakotan in and says that you're now going to participate, you're going to give your state-issued ID, because what it does is shift the burden. This does nothing as far as advancing protections for kids. We have protections there that already are in existence. If we were truly going to protect kids, we would age gate at the app level that is harmful, the people that are being sued by multiple AGs across the country. That if we really cared about kids, that's what we would do. We wouldn't drag in every 70-year-old who has a smartphone.
Thank you. Any other questions? All right. Oh, Rep. Jameson.
Question for the prime sponsor. Mr. Chair, the question really is effective date December 1st, 2026. Why December 1st?
Rep. Hughes.
John Hughes, State Representative, District 13. I would defer to Melissa McKay or Norman Woods. I don't know that there's any magic in that. Yeah, it's a transition period that's being allowed extra time as opposed to a July 1 commencement date.
Okay. Stay up there, Rep. Hughes. I was looking at Section 3, and we've heard a lot about how we verify the individual's age category by using A, commercially available methods that are reasonably designed to ensure accuracy, or B, an age verification method that complies with this chapter. Can you or one of your folks here describe what, I mean, is that just showing your driver license, your ID? We've heard it might implicate some kind of new ID form. Can you just speak to what that would mean?
Mr. Chair, John Hughes, District 13. I'm going to defer, but I will say this. South Dakota is a real ID state. So the idea that we're being pushed into real ID is a true red herring. Look at your driver's license. And so, but with that, I would defer to Mr. Woods.
Mr. Woods, Section 3, how to verify your age.
Norman Woods, Family Voice Action. Mr. Chair. Yes, so I would point to elsewhere in the bill, it says, for example, parental attestation, which is the fancy term for the parent said so. So how do you verify the age of a 16-year-old? It's because when the parent set up the phone, they said, my kid is in this age bucket. Doesn't give their birthday, just says within this age bucket. So that's how you verify the minor's age range. Nobody even has their birthday. The bill allows for that. For an adult, if you've got Apple Pay, if you've got credit cards saved to your phone, you can't get a credit card at 12. So that's a reasonable verification method. If your phone is set up under your name, your credit card is added to your phone, the company can reasonably assume we are owned right now, we are being in the hands of an adult. It can be as simple as that.
Thank you.
Your question?
It does. Thank you. Any other questions? Rep. Overweg.
Stay right there. So on that, Mr. Chair?
Go ahead.
So on that same line of questioning, I don't have any of that stuff to my phone. How will I verify my age?
Mr. Woods.
So there's a wide range of options. The credit card already being on your phone is just one of the easiest. A lot of phones already have your birthday or other ways of verifying your age. If needed, there are also third-party, they call it zero-knowledge proof, to where another company with absolutely no stake in the game could verify your age and then send a code back to the phone. That's the most obtrusive, and even in that example, the phone still has none of your data. So the credit card's kind of the easiest, and there's multiple other ways that most phones already have all the data they need.
Okay. Any other questions? If not, we'll move to committee discussion and or action. Representative Gosh.
I'll move do pass.
Motion by Gosh, second by Hanson. Do pass. Any discussion on that motion?
Mr. Chair, thank you. A lot of great points brought up by a lot of great people, and I appreciate everybody's insight on this. As a father of three, ranging from 16 down to 9, I fully understand what's going on. Me and my wife early on decided that we weren't going to give our children smartphones. Unfortunately, they don't make flip phones anymore. Well, they do, but it's really hard to find one. I have gone through, and I do consider myself relatively technologically savvy, and I've gone through protections through my cell phone or through my kids' cell phones. I've got every app you can imagine. I pay for some apps to try to ensure that my cell phones or my kids are protected. My kids have to have them because as a farmer and a rancher, there's a lot of times I send my 12-year-old son, 13-year-old now, just turned 13, sorry, 13-year-old son out into the pasture by himself to fix fence or move cattle. And I like that area of contact, or if he's even running a baler at this particular point in time. Some of the things that especially ranch kids get into can be relatively dangerous, and I like that level of communication with my children in the event that they get into a hairy situation. That being said, I am constantly chasing my children on limitations that I've put on them, and they're still getting around it. They're still finding a way around it. They may still find a way around this, but it's an added protection as a parent that I really enjoy and would appreciate getting through on this particular situation, that the phone just says, hey, my kid's 13. I don't want him looking at this stuff. So I will vote yes on this bill. Thank you.
Thank you. Any other discussion on the do pass motion? Representative Reich.
Thank you, Mr. Chair. Well, I'm going to resist the motion. We cannot abdicate our responsibilities as parents to the state legislature. You know, this bill, the intent of this bill is fantastic. You know, nobody wants kids viewing inappropriate comment or content. But, you know, we pass this thing, we're going to just get right in line with the other states that are being sued. I think the author of the bill understands, you know, with the weird effective date on it, that it's kind of something that is not ready for prime time. And so it's on the parents. You know, I think the testimony on the retailers was especially powerful as well, that well, it's going to tip a lot of things upside down that weren't even talked about today. And when apps changes, all of a sudden we got to re-verify. It's just a little too soon. I think that the bill sponsors got his heart in the right place, but this thing is not the answer.
Thank you, Representative. Any other discussion? Rep. Healy.
Thank you, Mr. Chair. I didn't know how I was going to vote on this today. I quite honestly didn't know entering into this room. I feel like I've had a lot of conversations with folks in this room about this bill. And I have a little bit of a funny story for you. So I have a 13-year-old, very similar ages to Representative Gosh's kids. And my stepdaughter was Googling our past governor. And we actually got an alert about it. My husband got an alert about her, even Googling a national news story about our past governor. And I think that just shows the effort that can already be put into parental controls. I also just went on to just Apple's support page, and I'm looking through the content that I didn't have to purchase. And it already shows how to prevent explicit content. And it even gets into games and what your kids can do when it comes to gaming, who they can add, how much time that they can have. I mean, that's just like one section that I'm looking through. I feel like the tools are already out there and already exist. And I remember last year we had a conversation about age verification when it came to porn websites. And this seems like a very similar bill in the way that I'm not willing to share my personal information or my kids' personal information or my credit card or my anything in order to do something that can already be done. So again, I didn't know how I was going to vote on this today, but it's pretty clear that this content is already there. The controls are already there. So I'm going to have to also resist this motion today.
Any other discussion on the motion? Rep. Heineman.
Thank you, Mr. Chair. The previous speaker brought up the last year's age verification. That reminds me of the parents that came up to me after we passed that legislation last year and thanked me for that, because they were not knowledgeable of what their children were seeing in our libraries. And they were appreciative that the fact that that brought some semblance of understanding as to what they can and able to do to help protect their children. And this is similar. I see it as a way to bring to the parents that we have a way of dealing with this issue on a large scale. So I urge you to support it.
Any other discussion on the motion? Okay, hearing none, then the motion is due pass on House Bill 1275 as amended. Those in favor will say aye. Those opposed, no. The secretary will please call the roll.
Representative Baumüller.
Aye.
Emery.
Nay.
Gosh.
Aye.
Hanson.
Aye.
Healy.
No.
Heineman.
Aye.
Jameson.
Aye.
Lems.
Aye.
Reich.
No.
Schaefbauer excused. Soy excused. Overwig.
Aye.
Odenbach.
Aye.
8 ayes, 3 nays, 2 excused.
After receiving a majority of members-elect, the due pass motion passes. House Bill 1275 as amended goes to the floor with a due pass recommendation. Okay, we will move on to our item number 2. We have 1 hour and 15 minutes left, 3 bills, so 10 minutes aside. HB 1196, provide for the participation of delegates from this state in an Article 5 convention and to provide a penalty therefore. Is there any proponent testimony?
Good morning, Mr. Chair.
Good morning, Representative.
Leslie Heineman, District 25, Moody and Minnehaha County. Thank you for this opportunity to be here in front of you. I have here House Bill 1196, basically dealing with the participation of delegates from the state in an Article 5 convention and to provide a penalty thereof. Probably the best way to explain the reason this is in front of you is, in fact, we will be discussing a COS, Convention of States application resolution here coming up in the next day or two. But this legislation helps answer some of the questions some of you have about the delegate selection that we would be sending to that convention if we were to engage in that. And I think it gives kind of some comfort to some of you that are questioning what will happen with this convention. So I think the easiest way for me to do, it's pretty mechanical in nature. I'll just quickly go through page by page what it does, and then if you have some questions, people following me as well, we can answer them. First page deals with terms, basically a definition of the terms of what a delegate is, Article 5 convention, etc. A way to recall. You can take a look at that. The taking of the oath is important because it binds the delegate to the process of what's going to be happening in this convention. If we go to page 3, it talks about individuals that has to be 25 years old, resident, etc. You can take a look at that yourself if you want. It's interesting. It says that you cannot hold a federal or statewide office. So the delegate selection would be involved in who those individuals would be excluded at that time with that selection process. Appointing 5 delegates, it'd be through our state legislature. We would be doing that as a body. And if state legislature was not in session, the E-Board would be the one that would be doing that. Page 4, and again, I'll run through this quite quickly. It deals with how the legislature can give guidance by resolution. and we do that now, how to appoint a different delegate, and the salary. Some people have asked about that. Well, is this delegate going to be paid? And it's basically mirrors what you're making as a legislature, which I'm sure most of you know is not a lot. But and page 5 talks about no gifts greater than $200 salary is not considered a gift. So if your employer or you continue to take a salary, you can do that and still function as a delegate. It talks about organization of the delegation. Majority is a quorum. There would be 5 members that would be selected. And then on page 6, the E-Board would monitor those delegates if they exceed their authority. So again, it's I'm limited on time, but the process of selection for a delegate will be now, if we pass this, will be in codified law, so it will give comfort to some of those that question whether a delegate or delegates, by the way, one of the questions is it going to be one delegate, one state? And this sets out that because there are some states that would like to have more than one delegate in the convention. And this specifically states that there would be one delegate, one vote per state. I think probably with that, there's others that'll follow me. If you have any questions, I'll be available. Thank you.
Thank you, Representative. 6 minutes remaining. Any other proponent testimony?
Good morning, Mr. Chair and members of the committee. My name is Shirley Meyer. I'm a volunteer state director, and I'm in District 14. And I agree, there are many people who have asked me about what the delegates would be and who would choose them. The legislatures would choose them, as he just discussed. Also, this would be good for all Article 5 conventions. And I urge you very much, because this is very much needed, it would stop a lot of questions out of there. It explains the delegates. It also is in there that one of their commissions is one state, one vote. A lot of people will say, well, California will come in with 15 delegates and they get 15 votes. No, it's one state, one vote. That is also in this. And I would ask you, because I know we're running out of time and it's short, but if you would please vote yes on HB 1196, and I'll stand by for questions if you want them.
Thank you, Ms. Meyer. Any other proponent testimony? 5 minutes left.
Good morning, Mr. Chair, members of the committee. Deanna Beckett, Regional Director, Convention of States. Almost a me too. I reiterate everything that our sponsor and Shirley has mentioned. Just wanted to point out that this gives you the control as state legislators, and it prepares South Dakota to be ready as we move closer to 2/3 of the states calling convention. And as mentioned before, that this bill will also include all articles of application, both previously and in the future.
Thank you. Any other proponent testimony?
Rick Santorum, former senator from Pennsylvania. I just want to make a very quick argument that one of the principal reasons people oppose an Article 5 convention is because they say we don't know what the rules are and we don't know that you can limit this convention. This limits the convention. The delegates of this convention take an oath that they will be limited on what they can vote for based upon what the subject matter of the convention is. And recall, a convention will not be called unless 34 states agree to the exact language of the convention. If it matters to call a convention that you need 34 states to agree to the exact language, then that language matters at the convention. And this resolution holds your delegates. 12 other states have passed almost identical legislation. Others will do so. That says that those people have to take an oath saying they will limit their votes to subject matters that are contained in the resolution. And if they don't, under this law, they will be subject to criminal prosecution. Not that I think that that will be necessary, but if you had any concerns, I don't think you're going to go to a convention in front of God and country, violate your oath of office, break the law, be subject to criminal penalties, and then have to come back to the people of South Dakota and explain why you did all that. So the idea of a runaway convention is an idea that, by the way, didn't exist until about 50 years ago. We've had this in place in the Constitution for 250 years. And this is sort of a recent thing. Now, I understand people are more and more concerned about how people behave in public office. But this is the belt and suspenders and super glue that make sure that this convention can go nowhere but what it's intended to do. Thank you.
Thank you, Senator. Any other proponent testimony? Anybody online? Nobody online, okay. Any opponent testimony then here in the room today?
Morning, Mr. Chairman, members of the committee. I'm Linda Schauer, Concerned Women for America, LAC. I need to pass these out. Thank you. I'm passing out the Article 5 Convention, the words of the Article 5. And you will see that the first two words of Article 5 are the Congress. Congress calls the convention when 2/3 of the states apply. Sorry. States do not call the convention, Congress does. A careful reading of Article 5 is clear that the only two duties of the states are to apply to Congress for a convention, and that is what SCR 503 does, that we just had recently. The states make the application to Congress. The only other responsibility of the state legislature is perhaps ratifying an amendment that may come out of a convention. I say perhaps because Congress could have state ratifying conventions instead. Congress chose to ratify the 21st Amendment via a ratifying convention. Our Constitution was ratified by state ratifying conventions. Article 1, Section 8, Clause 18 is known as the Necessary and Proper Clause. It states, and I quote, "The Congress shall have power to make all laws which shall be necessary and proper for carrying into execution the foregoing powers," unquote. Once again, the first words of Article 5 are the Congress. Congress has the power to call the convention, setting time, location, date, and process for delegate selection. In 1921, in the Dillon versus Gloss case, the Supreme Court opined that the Constitution speaks in general terms, leaving Congress to deal with subsidiary matters of detail. When the convention is convened, the delegates are independent representatives of the people. It's a federal function. Delegates are not controlled by the state legislatures or the Legislative Research Council. Remember, according to Article 5, the states only have two functions. So at the convention, the delegates can make the rules, write amendments, suspend the rules, or even draft a new constitution. On Thursday, February 23rd, 2023, Mark Meckler, president of the Convention of States Project, testified in favor of SJ 11, a joint resolution with language promoted for applying for a convention. In a hearing before the Wyoming House Revenue Committee, Meckler was asked by State Representative John Baer about delegate limitation acts to try to control the delegates to an amendments convention. Mr. Meckler responded that he felt such laws were, quote, unnecessary, but they make people feel better, unquote, about applying for a convention. And I have the link to that on the bottom of that page. So please send this unnecessary and feel better bill to the 41st day. And I have another handout, a diagram of a federal court case recently that explained that the Congress will be in control.
Thank you. Any other opponent testimony?
Good morning, Chair, Committee. My name is Scott Granville. I'm from Pierre, private resident or private citizen. I'm a chaplain. I've been watching a lot of Olympics, and I'm amazed at the curling. And despite having watched a lot of it, I'm not sure about the rules, but they are. And it's the World Curling Federation that sets up the rules. Norway can't come and say, these are the rules that I abide by. It's the World Curling Federation that sets up the rules. And it provides for fair and solid, good competition. The Senate, the United States Senate, has passed Bill 1272, and that does the exact same thing as what the bill that you're going to vote on does. And these are some of the things that the Senate has said about a constitutional convention. It provides that questions arising as to the convention's procedures shall be determined solely by Congress. It further states in Senate Bill 1272 that has passed Congress elects one delegate from each congressional district. That could cause us some troubles here in South Dakota. That means California would get 52 and we'd get 1. All of this saying that it's not the state that gets to set the rules. It's the authority that sets the rules. And in this case, as Linda pointed out, it's Congress. And Congress, we've seen their intent. Their intent is as in Senate Bill 1272, that there will be one delegate from each congressional district, and Congress will set up and design the Convention of States. I agree with the problems that are to be addressed. I agree that delegate rules and protections would be necessary if an Article 5 or a Convention of States is called, but I disagree with Bill 1196. Its guardrails that are not comforting. They highlight the danger of a called convention with a Congress that has the authority. Thank you for your time.
Thank you, sir. Any other opponent testimony in the room? About 3 minutes left. Okay. Online, we have Eldon Stahl. Sir, can you hear us?
Yes, can you hear me?
Yeah, please state your name and give your testimony. You have about 3 minutes remaining.
Hey, Mr. Chairman, members of the committee, Eldon Stahl. I'm opposed to HB 1196. I've learned that these bills are primarily for pacifying concerned legislators to get more votes for an Article 5 constitutional convention rather than protecting against abuses. In 2011, I met David Biddle from the Balanced Budget Amendment Task Force. He had pushed for a constitutional convention since the 1970s and was lobbying the South Dakota legislature to renew its application for a constitutional convention for a federal balanced budget amendment. He floated the idea of running a bill to try and control the delegates from the state to such a convention. Next year, he returned. The legislature introduced a convention application and a delegate limitation bill, then did the same thing the following year. In 2014, the delegate bill was debated on the House floor, immediately followed by the convention application for a balanced budget amendment. The delegate bill failed, and when the vote for the application resolution came, one representative, a longtime convention supporter, pleaded with his colleagues, quote, "I'm disappointed that the previous bill went down, but folks, I'm telling you, this is the vote right here. This is the key vote. Please vote for this resolution. We need to move forward with the possibility of calling this convention," end quote. So I wondered if convention supporters sincerely believed that the delegate limitation bill was truly necessary and effective for controlling a convention. Why then did they keep pushing for a convention after the delegate limitation bill failed? In 2015, the delegate bill passed, immediately followed by the CONCON resolution. These folks would also always claim that the wording of the application resolution from each state had to be the same or similar to make sure that, one, Congress would know which resolutions to add up and that the convention didn't go astray. But by 2020, Biddulph and his friends had ceased to pick up any new states. So what did they do? Did they try to strengthen their Delegate Limitation Act language? Well, no. Actually, they began pushing for Congress to call a convention by adding up unrelated applications. Now he proclaimed, quote, one state should pass one resolution that says, here are 34 applications, 28 on a single subject and 6 on any subject, and we're going to demand Congress call the convention, end quote. His new model resolution affirmed, quote, this application is to be considered as covering the same subject matter as the presently outstanding balanced budget and unlimited subject applications from other states, end quote. No more talk of limiting convention to a balanced budget amendment. They openly proclaimed, came out in support of unlimited conventions and for adding up unrelated resolutions to trigger a convention. They even insisted on ratification by statewide popular votes. The new plan argued that Congress was simply counting the wrong way and should have called a convention in 1979. And the strategy was to get states to sue Congress to get the Supreme Court to force an unlimited convention. And today we have people pushing a constitutional convention through another group that has already admitted that they don't think these delegate bills are necessary. But now they support it? Could it be because they're looking for 36 votes? Why should we continue to place confidence in claims, lobbyists, and strategies that have proven insincere, unreliable, and manipulative? I give you my solemn witness that these machinations are going on and pray that they be extinguished. So please vote no on HB 1196. Thank you.
Thank you, Mr. Stahl. We are out of time. Is there any final Me Too's? Okay, then we will give the Prime a chance for a rebuttal.
Thank you, Mr. Chairman. I sometimes wonder whether...
Welcome, Senator Santorum.
I'm sorry, Rick Santorum, former senator from Pennsylvania. Sometimes wonder whether the people testifying don't really understand what they're testifying on or whether they're trying to deliberately mislead. The gentleman came up and talked about U.S. Senate Bill 1272 and that Congress had passed this. Congress didn't pass Senate Bill 1272. The Senate did, but the Congress did not. And it was over 50 years ago. In fact, no other bill has been introduced since then. It was done after the Roe versus Wade decision came down, and there was an effort by some of the left in Congress to pass a resolution or a bill to try to constrain any convention of state from they were popping up, trying to overturn Roe, and so they wanted to take control of that. It didn't pass, and nothing's been introduced since. And by the way, nothing had been introduced for 200 years before that. So the idea that somehow another Congress thinks they can control things, it didn't happen then, and it wouldn't happen now. In order to do that, you'd have to get a majority of the House and a supermajority of the Senate and a president to sign it. And given the fact that if this convention of states is going to happen, 34 states would have to agree, which means 34 states in all likelihood would have to be in Republican control. Highly likely that a Republican House and Senate and president, given 34 states being in Republican control, would try to overturn what the rest of the country would want to do. It doesn't make any sense. The overall question on that is, there are two elements of Article 5. One gives the Congress the power to propose amendments today. They wanted to propose amendments to eliminate Christmas, they could do so today. Congress has absolute power to propose any amendments they want to do. The idea that the founders would put in place a second provision, specifically giving state legislatures the power to propose amendments, and say Congress controls that, makes no sense. Why would Congress have to control, why would they set up something where Congress controls both processes when the Congress can do something directly? Now they're going to do it indirectly through the states. It makes no sense. No court, nobody would suggest that somehow Congress controls a provision specifically put in by the founders because they didn't think Congress would limit their own power, go to the Constitutional Convention, listen to the debate, and that's exactly what it was there for. This idea that Congress controls everything is nonsense. I understand people maybe believe it, but it's nonsense. Secondly, someone brought up the Kansas decision. I know you were handed that. The Kansas decision was a very simple decision. Article 5 gives specific power to you, the state legislature, to decide whether to have a convention or not. Kansas Constitution limited your power. The Supremacy Clause says they can't do that. But for 10 years, Kansas legislature limited their power by passing rules that said that they needed 2/3 to be able to pass an Article 5 convention. And guess what? They never passed it because they couldn't get 2/3. But what happened that allowed this Kansas case to be considered is that the state legislature changed their rules. Last year, they changed the rules and they removed the 2/3 from their rules. Because they removed the 2/3 from their rules, so they weren't limiting themselves, the court decided Kansas Constitution cannot limit them. It is a very simple case. It doesn't say Congress controls things or the federal government controls things. It's simply a simple constitutional case. The final point I'll make, there's many more I could, but the final point I make is someone suggested that Mark Meckler or others testified that this was unnecessary. Well, yes, it's unnecessary, as I even suggested in my comments, that this is super glue, belt and suspenders. This is just another way of saying, to give comfort to people, that there are plenty of ways to control this convention, even without this. But in fact, this would be helpful in giving an additional layer of protection. Just because you ask for an additional layer of protection doesn't mean that you're insincere about the original layers of protection. Again, I question whether some people are trying to mislead or they simply don't understand. But the reality is there are plenty of protections in place to make sure that this convention is run according to what the people of South Dakota through this resolution would like to see done. Thank you.
Thank you, Senator. With that, we'll close the taking of public testimony, open it up to questions from the committee. Would remind everyone we have 45 minutes left, roughly, to hear 2 more bills after this. So with that, any questions from the committee? Any questions? Okay, hearing no questions, we'll move then into committee discussion and/or action. Representative Jameson.
I'd make a motion for due pass.
Motion by Jameson, second by Hanson for due pass. Is there any discussion on that motion?
I just was really, Mr. Chair, I was really struck by the suspenders, super glue, and what was it? Belt. Yeah. So I think the message of kind of a reassurance is probably needed for a lot of people, and I think this lays it out very well.
Any other discussion on the due pass motion? Representative Gosh.
Substitute motion.
Substitute motion. State your motion.
Move to the 41st day.
Motion by Gosh, seconded by Emery for the 41st day. Any discussion on the substitute motion?
Mr. Chair, thank you. Taking a look at this bill, there's a few issues that I have with it, just internally and administratively, particularly Section 7, Section 14, Section 15, in which it gives kind of an unfettered authority to the executive board and flies in the face of our codified law 2-9-4. The executive board of the legislature is essentially an administrative portion of the legislature while the legislature is not in session. And if you go through 2-9-4, it's quite laid out on what the executive board's authority is and what it's intended to do. I fear this goes a little bit too far. I've served on the executive board for coming up on 8 years now. I was a former chair of the executive board. Looking at what it's intended to do, it gives way too much authority to the executive board, especially when not in session. I don't think it falls under what the executive board is supposed to do. It gives it too much authority and too much power in an area that the legislature should be the one that deems necessary in that area. So because of that, I can't support this bill. Thank you.
Thank you, Representative. Any other discussion on the 41st day motion? Representative Heineman.
I'd ask you to resist this motion. Certainly, he's pointed out that the executive board has a capacity to make decisions. The question is whether in this particular situation it's a good idea or not. I know there are other situations where the E-Board has made decisions when the legislature is not in session, so I think it's appropriate that they would be the one. So I urge you to not support this motion. Thank you.
Any other discussion? Okay, then the motion is to send House Bill 1196 to the 41st day. All those in favor will say aye. Those no, the secretary will please call the roll.
Representative Baumüller.
No.
Emery.
Aye.
Gosh.
Aye.
Hanson. Healy.
Aye.
Heineman.
No, no.
Jameson.
No.
Lems.
Aye.
Reich.
No.
Excused. Schaefbauer. Excused. Overwig.
Aye.
And Odenbach.
Aye.
6 ayes, 5 nays, 2 excused.
Okay, after failing to receive a majority of members-elect, the 41st day motion fails. Do we have any other motions? We're back on the original, aren't we? Okay, well, the original is due pass. Any further final discussion on due pass? Okay, then hearing none, all those in favor of due pass will say aye. Those opposed, no. The secretary will please call the roll.
Representative Baumüller.
Aye.
Emery.
No.
Gosh.
No.
Hanson.
Aye.
Healy.
No.
Heineman.
Aye.
Jameson.
Aye.
Lems.
No.
Reich.
Aye.
Schaefbauer excused. Soy excused. Overwig.
Aye.
Odenbach.
No.
6 ayes, 5 nays, 2 excused.
After failing to receive a majority of members-elect, the due pass motion fails. Is there any other motions that might be relevant? We could defer, we could send to the floor with no recommendation, we could do all manner of things, I don't know. Representative Overwig.
Can you defer it to this afternoon?
Yeah, we'll defer it to this afternoon.
Just action.
Defer action to this afternoon and see if we can get more people to show up. 1 minute.
I think because the agenda is set, we have to.
So the chair will entertain a motion to amend this afternoon's agenda to take up this matter for action this afternoon.
So moved.
Second.
Motion by Overwig, seconded by Gosh. Any discussion on that? Okay, so the motion is to amend this afternoon's agenda to take up this matter for action when it is deferred. All those in favor of the motion will say aye. Those opposed, no. Let's do a roll call, please.
Representative Baumüller.
Aye.
Emery.
No.
Gosh.
Aye.
Hanson.
Aye.
Healy.
No.
Heineman.
Aye.
Jameson.
Aye.
Lems.
Aye.
Reich.
Aye.
Schaefbauer excused. Soy excused. Overwig.
Aye.
Odenbach. 9 ayes, 2 nays.
Okay, after receiving a majority of the members-elect, the motion to amend this afternoon's agenda to take up this matter passes. We will add this to this afternoon's agenda. We will now move on to House Bill 1222, prohibit members of the Board of Economic Development from having any interest in monies from or approved by the Board of Economic Development. Representative Lems. 10 minutes aside, just to remind everybody, we've got about 45 minutes, maybe 50 minutes if we go long.
All right, I'll try to make this quick. Good morning, Chair and members of the committee. As was mentioned, I bring you House Bill 1222, which is an act to prohibit members of the Board of Economic Development from having any interest in monies from or approved by the Board of Economic Development. So today, I am bringing you this bill to protect the integrity of our state's economic growth objectives and shore up the public trust. So I have served with some of you over the summer and the fall on the Government Operations and Audit Committee, otherwise known as GOAC for the public, all these acronyms. During that time, concerns were raised with how the Governor's Office of Economic Development operates with our public monies. Some concerns were addressed in Senate Bill 1, which I was to prime sponsor over here in the House. That bill failed. And now we just passed House Bill 1286, which also addresses some of these issues. So just to give a brief background to those who are listening in the room and online, the South Dakota Governor's Office of Economic Development, otherwise known as GOED, was established in 1987 by then Governor George Mickelson. It is operated under the purview of the governor and is overseen by a board of up to 13 members appointed by the governor and 4 non-voting legislative members. It's a 4-year term, and these voting members are approved by the Senate. There is no term limit. All appointees, subject to Senate confirmation, must file a statement of financial interest with the Secretary of State. So, what does the board do? It reviews applications, approves incentives, grants, and awards designed for job growth and economic opportunities. If there is a conflict of interest, the board member must recuse themselves from discussion and abstain from voting. So I believe that many involved in this process over the last 39 years have had good intentions. But as with any institution, you are bound to have missteps over time, which lead to questions and eroding of trust by the public. So I understand that nonprofits and business boards have multiple members who often serve on various boards, often at the same time. But when we step into the public arena to serve on a board where taxpayer money is to be invested, it demands more than good intentions. We must avoid even the appearance of self-dealing. So as you all know, in the last year we had a board member who was serving on GOED, who also sat on the board of a company who benefited from millions of state dollars. These are taxpayer dollars. The board member was also was connected to the landlord of a building where the company was to have some of its offices. So even though the board member abstained from discussions and votes on this company in relation to GOED, the appearance of impropriety is glaringly obvious to the public, and it is not okay. We can do better, and we must do better. Don't tell me that we cannot find qualified people to sit on a board that don't have a conflict. As stated by one of our legislators who sits on the board right now, quote, "We cannot make informed decisions with public funds if it is clouded by undisclosed conflicts after decisions are made. Legislative reform is necessary now." So like I said, we can do better and we must do better. Please pass House Bill 1222.
Thank you, Representative. Any other proponent testimony? We're 3 minutes in, 10 minutes aside.
Good morning, Chair and members of State Affairs. Representative Julie Auk, District 18, and I also serve on Government Operations and Audit Committee. And in reference to House Bill 1222, the Board of Economic Development is entrusted with directing public dollars, taxpayer dollars, into projects that are supposed to grow our economy, strengthen our communities, and create opportunity. For that work to be legitimate in the eyes of the public, people need to know one thing: that decisions are being made for the good of South Dakota, not for personal gain of the decision makers. This bill says that a member of Board of Economic Development may not have ownership, interest in, or sit on the board of any entity that receives an award, disbursement, expenditure, or grant of public money from or approved by the same board. In other words, if you're on the board, you don't get to sit on both sides of the table. You cannot help decide where the money goes and also profit from where the money goes and also profit from where the money goes. That's a basic conflict of interest, and the bill draws a bright, clear line against it. It is not an indictment of anyone serving today. It's a protection for them, for future board members, and for the public. It takes away the appearance of impropriety as well as the reality of it. Even when nothing wrong is happening, if citizens believe insiders are benefiting from public decision, confidence erodes. And that hurts every program we administer. We ask a lot of our citizens in terms of trust. Trust to collect their tax dollars, to distribute them, and to invest them in the state's future. We owe them policies that justify that. This bill is one of those policies. By supporting this measure, we affirm a simple principle. Public service is about service, not self-interest. The people of South Dakota deserve that assurance. It's clear law, not just good intentions. Please, I ask you to respectfully support this legislation. Thank you.
Thank you. Any other proponent testimony? About 5 minutes left.
Good morning, Chair, members. My name is Sarah Stever. I'm from Lennox District 6, and I'm here representing myself. I've served on many boards over the years, both local and national, and I still serve. I've also belonged to organizations that have received funding, so I've seen both sides of this. I know because I've served that camaraderie within a board builds trust among board members, but no one from the outside can possibly share that experience. The connections, relationships, and most importantly, the perception of favoritism remains, and in a small state like ours, perception is reality. I agree with what both Julie and Carla spoke about the situation. We know what this is about. And even with the recusal or disclosure, the optics damage public trust, which is a really fragile thing. We'd like to say it's robust, but it actually isn't. HB 1222 closes that loophole cleanly. If you want to help decide where public economic development dollars go, you cannot even have an appearance of a financial stake in the outcome. This bill is not anti-business, it is pro-integrity. Stronger ethics rules protect both the board and the businesses that receive awards from accusations of insider dealings. South Dakota should be above reproach. We should lead and not lag on government ethics. I urge you to pass HB 1222. Our taxpayers and our goal for clean, transparent government demand it. Thank you for your time.
Thank you, Ms. Stever. Any other proponent testimony? And there's nobody online, so we will then move to opponent testimony. 10 minutes.
Morning, Mr. Chairman, members of the committee, Bill Even, your commissioner at the Governor's Office of Economic Development. Here to speak in opposition to House Bill 1222. I think the core of my testimony excuse me, is going to revolve around just the practical nature of what we're attempting to do here. I think 1222, the way it is written today, is going to make it difficult to find volunteers, and I'll emphasize that word volunteers, that are both willing to serve on a board for the state of South Dakota and who also have the required experience and expertise to execute the work of the board. So as you heard from Representative Lems, the Board of Economic Development does have 17 members, 13 volunteers appointed by the governor, and 4 ex officio members of the legislature. Our office reports to the governor, not to the board. They serve as essentially a credit committee for the GOED loan funds. Now, the board and its associated credit committee meet monthly to review detailed confidential information related to loans that are in partnership with the private sector and businesses and banks. To give you a little sense of what that looks like, these meeting packets are rich in financial detail containing balance sheets, financial statements, personal financial statements, cash flow statements, net worth statements, business plans, collateral documentation, risk ratios, and background checks. These confidential board packets are sent out 10 days in advance of the board meeting, often run to over about 100 pages long. Analyzing this information and discussing these decisions does take time and expertise. Now, the board meetings are all posted in advance. There's an open session at the beginning to discuss the agenda, any issues or conflicts of interest that have been mentioned here, time for public comment, and then the board reviews the confidential information related to any loan analysis in executive session. They reconvene after that for discussion and action. The minutes of these meetings are all posted publicly and available for inspection. It's also very common for members of the press to attend these meetings as well. So with any board or commission or authority here in the state of South Dakota, the state is going to seek out people who have the relevant experience to work and make those sound decisions based on the specific duties of the board. So in front of you here, a map of the ready loans over the past 38 years across the state of South Dakota. I think it gives you a sense of that statewide engagement of the businesses and the communities across the state that are interacting with the Board of Economic Development. I think it demonstrates the ability to find people that have the requisite experience that are going to have zero potential issues with anything that may arise, because they may arise anywhere across the state of South Dakota. So regardless of any particular state board, there's occasionally going to be members that may have a conflict of interest, and that's why we have the state conflicts of interest laws. So South Dakota Codified Law Chapter 323 covers conflicts of interest for all state boards, authorities, and commissions. That's how every board handles these sort of issues in the state of South Dakota, and we are covered by this same set of statutes. Now, I also point out that South Dakota has got 145 boards, commissions, and authorities. Now, this bill takes aim at the Board of Economic Development specifically. So I think it's also worth noting that down the line, the precedents of this, we need to be aware of it, you as the legislature as well. Now, as a practical matter, I think it's impossible also to predict where the next project might be. People are either going to choose, well, I'm not going to volunteer to serve on the Board of Economic Development because I never know when something may come up, or the alternative may occur where you have a seated board member that's been serving effectively, and suddenly when an issue comes up, they're going to be forced to make a decision. They're going to have to resign from the Board of Economic Development or resign from the other organization that may be affiliated with. We do business with economic development organizations and nonprofits as well across the state of South Dakota. And the type of people that are attracted to serving and volunteering on boards and commissions in the state are often folks that are very active in their community. They're very active in their business interests as well. I would also point out that the ownership stake requirement as written in this bill is pretty broad. So anyone with a share of a publicly traded company, either through direct shares or think about your 401k mutual funds, for example, they're going to be ineligible to serve on the board if there's any sort of nexus involved in that. I would close, Mr. Chairman, with, I'd say, just kind of a general statement that, House Bill 1222 as written is going to make it nearly impossible for any governor to appoint a board with the experience and the competence necessary in the subject matter that the board actually works on. An analogy might be the governor would be forced to appoint diesel mechanics to the State Cosmetology Commission to ensure that there's never potential of an issue out in front. So I'd ask this committee to seriously consider the practical ramifications of this bill as written. And as I've mentioned with Representative Lems and others when we talked about this last week, we're willing to work with the sponsor to remedy practical problems as we see it with the bill. So thank you, Mr. Chairman. I'll stand by for questions.
Thank you, Mr. Even. 4 minutes remaining. Any other opponent testimony?
Good morning, Mr. Chairman, members of the board. Ryan Budmeyer with the South Dakota Chamber of Commerce and Industry. We rise in opposition to HB 1222. The people we want on the Board of Economic Development are the job creators, the entrepreneurs, business owners who actually understand how to grow the economy, not career bureaucrats or political appointees. South Dakota already requires disclosure, recusal on conflicted votes, and has government accountability laws that catch real misconduct. South Dakotans believe in individual liberty and holding people accountable for actual misconduct, not preemptively punishing an entire class of citizens because someone might abuse it someday. These appointed board members already serve at the pleasure of the governor and can be removed. This bill replaces accountability with a purity test. This is an extreme step that will harm our state's business climate, and we ask you to oppose HB 1222. Thank you.
Thank you, Mr. Budmeyer. Any other opponent testimony? About 2.5 minutes remaining.
Good morning, Mr. Chair, members of the committee. Arthur Wadsworth with Elevate Rapid City. We manage a series of programs that have the same goals and purposes as the board being discussed today. We have a seed fund, a couple loan committees. In order to make sure that we responsibly manage those funds, we do exactly what is being described today. We build committees and boards to review those decisions. That helps us ensure that those dollars are deployed effectively and make sure we're not mismanaging those funds. And so if we want to be responsible stewards of taxpayer dollars, we need to go to the lengths of ensuring we have adequate industry input to make sure that we're making good decisions. Would ask for your opposition. Thank you.
Thank you. Any other opponent testimony? Okay, nobody online. We will then give the prime a chance for a rebuttal.
Thank you, Mr. Chair. And I don't think I said before, I'm Representative Carla Lems from District 16. So, this is not an extreme bill. This is a common sense bill. The GOED board is the one that has the public perception problem, and that is why this bill addresses just that board. And I will just say that the public agrees with me on that. We are literally at a crossroads in the state when it comes to the public and their trust in their government. And if you haven't noticed, they are getting a bit fed up with the lack of transparency and oversight that they perceive, right or wrong, to be backroom deals. This is not an accusation from me of wrongdoing. This is about shoring up the public trust. We have seen in recent years how the absence of guardrails leads to controversy and puts doubt in the minds of our citizens. This bill builds on recent executive actions and legislative discussions by bringing common sense to the issue of serving on this board. This does not prevent the board from doing their work and GOED continuing to seek legitimate economic growth. I will just mention that I did a quick search of professionals in our state, and of course I could add to this list, but 5,000 realtors, 60,000 in healthcare, 2,000 lawyers, 28 land developers, 115,000 in agribusiness, 11,000 in banking. I think we can find people who would be willing to serve on this board without a conflict of interest. So what does this bill, at the end of the day, what does it do? It prevents the conflict of interest, it promotes the public trust, and it raises the integrity bar a bit higher so our state's palms up approach will be on display for all to see. Please pass the bill.
Thank you, Representative. With that, we'll close the taking of public testimony and seek any questions from the committee. Representative Hansen.
Thank you. This is for Mr. Even. Mr. Commissioner, thanks for being here. You had said earlier in your remarks that it would be difficult to recruit board members if a measure like this was passed. And so it just led me to wonder, and the reason for the question, how many recusals have there been lately because of a conflict of interest with a member of the Board of Economic Development who had an ownership interest in a grant or loan recipient?
Mr. Chairman.
Commissioner Even.
Yeah, Bill Even, your Commissioner at Economic Development. Thanks, Representative Hansen. I started here in May, and off the top of my head, and I can certainly refer to staff, but I believe I've seen probably 3 or 4 since I've started in May of various individuals on the board when the issue came up where they, stepwise, you make notice and to the entire board that I have a conflict of interest. That's done in the public session component. And then they recuse themselves from the conversation as well as from voting.
Follow up.
And were those because they had a direct ownership interest in a potential grant or loan recipient?
Mr. Chairman.
Mr. Even.
Representative Hansen, if memory serves me correctly, you have folks that are serving on the Board of Economic Development that also might be on bank boards or work for banks, and those banks would be partners with a particular loan with GOED and a particular project. So those are the sort of situation that could arise as well.
Representative Heineman.
Thank you for the Commissioner. Thank you, Mr. Chair. The question of recusal, do you really believe, or I guess my question to you is, if one recuses themselves from a particular financial decision that they're a board of, do you really think that removes their influence as well on that committee?
Mr. Even.
Mr. Chairman? Yeah, thanks, Representative Heineman. My answer is yes. And the reason I say that, much like Sarah Stever, who's a friend of mine, testifying on the other side of this, we have all served on a number of boards and commissions over the course of our careers, myself included. And the reason that conflict of interest laws exist are to make sure that it's known, it's verified, and we're maintaining the trust that the sponsor, Representative Lenz, has mentioned. And when you look at the caliber and the quality of individuals that you want to serve on these different 145 state boards, commissions, and authorities, you're really looking for people that have that, I would say, that level of integrity where, just like you as legislators, you have your peer group, but you also are your own independent individuals. And so you're subject to making your own decisions with your own mind and your own best judgment and the interests of the state at heart in whichever commission that you're serving on.
Okay. Representative Overweg.
Thank you, Mr. Chair. For the commissioner, so without saying too many words, we know probably why this bill is here, and you and I have had conversations, politics, perception. So you don't like this bill, you don't like what this does. What are you suggesting from the inside you could change to get me not to vote for this bill?
Mr. Chairman.
Mr. Even.
Mr. Overweg, I think the fact of the matter is that when you look at the ownership interest requirement is, as I mentioned, is pretty exceptionally broad that could inadvertently catch people in that sense. In addition, I think you just refer back to the fact that the state does have very robust conflict of interest laws in place, both for state employees like myself or for members that serve on boards, authorities, and commissions. And so ensuring that those conflict of interests are disclosed on an annual basis, I think is really important. Every board that I've ever served on has required that, and those things for the state of South Dakota are listed publicly so that there's that notice. And then the next backstop is the existing conflict of interest laws, so when something pops up unbeknownst to someone, because these projects come in from all different directions over the course of the year, that you have really sound procedures in place, that those are being done in open session so the members of the public are aware of that, and that we're maintaining that integrity. In addition to that, I think a suggestion that I would have, and one thing that I always did, whether I was on a board or serving as a CEO or executive director, I ensured that you had your legal counsel on an annual basis have a sit-down presentation and training for the board of directors to remind them, here are your duties as a board member, here are what conflict of interest means, and this is why this is taken seriously and why you must abide by it. So that is probably the belt and suspenders approach that I would suggest, Representative, that we look at those sort of things to ensure that we're not having the exception swallow the rule here just for the Board of Economic Development.
Thank you.
Thank you. Any other questions? Representative Jameson.
For the commissioner, thank you. So on the recusal process, when you said, I think you said, mentioned refrain from the discussion or remove themselves, does that mean literally remove them from the room, from the presence? What's that all entail?
Mr. Chairman.
Mr. Even.
Representative Jameson, this board meets electronically, and so the people aren't physically in the room together, they're on the phone, as it were, on a teleconference. The board does meet in person once annually for an extended period of time, and so that would be one occasion. That is certainly an option, of course, that the individual can do. They can choose to physically remove themselves from the room, but with the majority of the meetings happening telephonically, they're not physically present together.
Follow up, Rep. Jameson.
So just that, as you say, on the phone type of a meeting, would they not be, when you say recuse, would they still be in the meeting, but just not voting on the item and just silent, or would they drop off the meeting, drop off the call?
Mr. Chair.
Mr. Even.
Representative Jameson, typically what I have seen is that they remain silent, remain on the call, because as the call proceeds and that topic moves on, then there's a different topic that they do not have a conflict, and then they have to exercise their duty as a board member to comment and weigh in.
Follow up? Rep. Jameson.
Yeah, thank you. I just enjoy this little conversation, if you don't mind, about the perception of misconduct, frankly. I've just had a few experiences in myself recusing during a city council meeting, and it was always recommended that we leave the room completely so as not to be seen, heard, potentially react. Any of that was always just better to be gone. Just sensing that as you're looking for new ways to maybe improve this process, I would recommend one of them could be is they just not, they got to get off the call and they get back, just to remove themselves from the, as you look at a phone or a list, I think you could see their face, their name potentially, I'm not sure, but just a suggestion, I guess if there's a question here, do you agree with something like that?
Mr. Even.
Mr. Odenbach, thank you, Mr. Chairman. Representative Jameson, I think that's very doable. I think that's, with technology today, the ability to have someone exit that portion of the executive session so that they're not present, and the ability to signal to them to get back onto the call should be very doable.
Okay, any other questions from the committee? Representative Reich.
For the bill sponsor, please.
Go ahead.
So I'm looking at I think the incident that brought your bill, and you have the handout here, and so I'm just curious if this bill passes, when does this action take place? So in the matter of the Schwans wanting to build the 600 employee production plant, and the board member recused himself in compliance with current law, but if your bill passes, at what point in time, let's just use this exact scenario, at what point in time would that board member resign from the board when the thing is being considered, when an award is made? Just how would this mechanically work?
Well, obviously this...
Representative Lems.
Mr. Chair. Obviously, if the bill goes into effect, it will be July of this year if it was signed. And so I believe at that time, midstream, you know, there would have to, I mean, the award has already been gone out, right, to this particular company.
I'm sorry.
Representative
I maybe
Reich.
didn't put my question. I'm not saying this would be unwound. I'm just saying a new case comes forward.
Okay.
Similar circumstances. One of the board members has an interest, and this law is in place.
Mm-hmm.
At what point in time would that board member say they see the agenda's coming up, something, would that be the time that they would be expected to resign from the board?
Mr. Chair?
Representative Lems.
Yes, I would say that would be the time.
Okay, before it's even considered.
Mm-hmm.
Okay, thank you.
Any other questions from the committee? Okay, then we will move on to committee discussion or action. Representative Gosh.
Thank you. I'll move due pass.
Motion by Gosh, second by Hanson on due pass. Any discussion on that motion? Any other discussion, thoughts on the due pass motion? Rep. Hanson?
Well, thanks, Mr. Chair. You know, with 17 board members on the Board of Economic Development, over 900,000 people in the state of South Dakota, you know, we heard sort of a listing of all of the professionals in this state. And frankly, most of the professionals in the state, most of the entities in this state don't receive any loans or grants from the Board of Economic Development. So I do think that there are a lot of competent professionals who could serve on this board with the passage of this bill. The argument was made that this would sort of be a slippery slope as it applies to other boards. But, you know, we're talking about the Board of Economic Development here that is giving out a lot of taxpayer money and without any oversight from this branch of government. That's not all other boards. That's a special case. And so I do think that there should be a heightened standard when it comes to the Board of Economic Development, when it comes to distributing taxpayer money. And to Representative Heinemann's question from earlier, I don't believe that recusal in this case removes influence. I don't think it's enough. You know, especially in the case of a smaller board like this. If it's a larger board, like the legislature, for example, I think that's an appropriate measure. In other cases where I don't believe that there should be a heightened scrutiny, perhaps it would work. But in this case, it's just not removing the influence, and I think that we all kind of know that. I think we can all recognize that. And as we heard in the back and forth, you know, up till this point, they've not even been actually recusing themselves from the meeting. They've still been present in the meeting. So I just think we deserve it to give it to the taxpayers, you know, whose money is actually being collected and distributed by this board, to ensure that even the appearance of impropriety is avoided and that we're completely above board, and this bill would help to do that. And so I would appreciate your support of this motion. Thank you.
Thank you, Representative Hansen. Representative Jameson.
Thank you. I'd urge the committee to resist this motion. I think we have a very good commissioner. I trust him, and his openness to do a better job was clear today. There are already currently plenty of rules and regulations regarding conflicts of interest that are existing today. So I'm going to take the commissioner's word that it would be hard for them to find members. I trust him in that. I trust his other approaches as well. So I just urge you to resist this motion.
Any other discussion on the do pass motion? Representative Lems?
Just a few comments, Mr. Leader. Obviously, I want this to pass. What I would say is it's not about the person that's in the office today. That's not what this is about. We don't know who's going to be there next time. And so this is setting something up that will ensure that we have guardrails in place, whoever the governor is, whoever the chair of the Economic Development Board is, whoever the commissioner is, that we're going to have public oversight, that we're going to have clear guardrails in place so that the public can trust this system and this board going forward.
Any other discussion on the motion? Rep. Overweg.
Thank you, Mr. Chair. Real quickly, first off, you know, my respect for the commissioner and the deputy commissioner, I can't even measure it. I mean, I've worked with them and stuff, and the trust for them is there. But I look at us as legislators and what we have to hold up to. You know, we lost a good legislator that couldn't run because he was having questions from fixing urinals in the interstate road stops, that it was conflict of interest. So we go through that here too. And to the commissioners about the diesel mechanics and cosmetology, you can't get me started on how many people that governors and presidents have pointed to agriculture boards that wouldn't know one end of a cow from the other. So we go through that too. So thank you.
Representative Heineman.
Thank you, Mr. Leader. Well, I feel bad because previous individuals in this department have put our legislature at odds with what's happening. That's what's unfortunate. We're forced here to make a decision based on what's happened in the past. And I happen to think that the future is very bright for this department. I think that I respect the individuals that are here, and I'm glad to see that. So I agree with the previous legislator that mentioned that. But I feel bad because we're put in this position from past experiences and from past acts that they did. And we have to respond to a public outcry that's going on here. So, you know, can we say, well, everything was fine, we didn't like what happened, but we'll go forward and we won't have any issues? Or do we say, no, there has to be some accountability here? And that's what's difficult for me. I'm really struggling with this particular issue. The idea of recusal, I've been on boards where I've done that, and if you sit in the room and listen to the discussions, there's influence there. That was my point. It's really hard not to have that. I don't know how you get around that, because you need good people on those boards. You really do. But for those reasons, you know, I'm going to support this.
Any other discussion on the do pass motion? Okay, then the motion is do pass on House Bill 1222. Those in favor will say aye. Those opposed, no. The secretary will please call the roll.
Representative Baummuller.
Aye.
Emery.
No.
Gosh.
Aye.
Hanson.
Aye.
Healy.
No.
Heineman.
Aye.
Jameson.
No.
Lems.
Aye.
Reich.
No.
Schaefbauer excused. Zoy excused. Overwig.
Aye.
Odenbach.
Aye.
7 ayes, 4 nays, 2 excused.
Thank you, Madam Secretary. After receiving a majority of members-elect, the do pass motion on House Bill 1222 passes. 1222 goes to the floor with a do pass recommendation. Okay, well, wonderful. We have about 6 minutes left and another bill on the agenda. We're going to have to end up deferring the bulk of this. What I would say is maybe pitch the bill, Mr. Prime, and then if there's anybody in the room, maybe pro or con, that absolutely can't be here this afternoon, come up and give a minute. But we'll get kicked out of the room well before then, so I'm going to defer the balance on this. So with that, HB 1246, Representative Hughes.
Thank you, Mr. Chair, members of the committee. John Hughes, District 13 representative. This is a very straightforward bill which honors the tradition of South Dakotans to have voter engagement. You know, we have the strong record from well over a century of public involvement in matters of public policy, public oversight, transparency of government. So what this bill does is it creates a presumption of openness as to any non-disclosure agreement or confidentiality agreement between a data center developer and a local government entity. Now, what does this bill not do? Well, I can tell you it doesn't ban contracts between data center developers and local governments. It merely states that such a document is presumed to be a public record unless it meets all of the other requirements as to confidentiality, non-disclosure, and redaction, which are all contained in Chapter 1-27 of our South Dakota codified laws. Now, I don't think I need to tell you that there is a major battle going on nationally over transparency versus secrecy between data center developers and local governments. And in fact, I can just tell you, Ohio has legislation going, Illinois, Michigan, Wisconsin, following a report that $57 billion in data center proposals were developed in secret. State lawmakers in Wisconsin have introduced a number of bills to regulate the industry, including a ban on non-disclosure agreements. Other states, Florida, Michigan, New Jersey, are considering legislation. So why do we need this? Well, here are the key issues of the conflict. One is transparency versus secrecy. Residents need to have a say in projects. If there are secret agreements, they need to know they exist and to engage their local government to have as much of those documents revealed as they can. There are environmental and infrastructure concerns dealing with water usage, high energy, noise pollution. You all know these things. We've all heard these things. We've learned about hyperscale loads. We've learned about huge demands for electricity. And here's another reason. South Dakota is one of the most secret states when it comes to forming a business entity. You know, back when I started practicing law, you could not set up a business corporation unless the owners were disclosed and a purpose was stated. Well, we've ventured way far away from that and are more like Delaware and Wyoming. And so I could set up a shell company. There could be a registered agent. The owners are not disclosed. The investors are not disclosed. But that's South Dakota. So it's a particular problem here. Economic development pressure. We all feel it. Local officials are often pressured or feel obligated to enter into non-disclosure agreements because, they think, well, let's not bring the public into this just yet. Let's not share information about potential community impacts. So if you take a look at the bill and then you take a look at the rest of Chapter 1-27, you'll see that this fits nicely into our open records laws, which I believe came to being in about 2009. And so I worked carefully with LRC to lodge this bill so that it fits within the existing structure and will protect the public. And there's a whole raft of exceptions to disclosure in 1-27-1.5, everything from trade secrets to attorney work product to appraisal information, correspondence memoranda, any document that is an internal agency record or information. So this doesn't upset the apple cart. I'm not picking on data centers. What I am doing is trying to encourage this legislature to provide as much openness as possible as we are asked to commit our resources and our land and our electricity, and in some cases our lifestyle and our country living to data centers. So that's really what I have to say, and I don't really have much more to say, but I'll certainly stand by for questions.
Okay, we have about a dozen people signed up, whether in person or online, and maybe about 7 minutes left in this room till we start getting kicked out. So with that, what I'm going to do is there anybody in the room who just flat out cannot rejoin us this afternoon? We're going to reconvene this committee right after. Is there any other proponents who cannot join us this afternoon, either in person or online? Okay, is there anybody who'd like to give brief opponent testimony of like 5 or 6 minutes? And then we're going to reconvene this. We'll restart with proponents, but we'll give them a chance. If so, we'll take some brief opponent testimony at this time. Go ahead, sir.
Mr. Chairman, Nick Phillips for Applied Digital. This bill will actually have the opposite effect of transparency than the intent has been stated. Everyone is watching South Dakota. This shows South Dakota is closed for opportunity, not open for it. When we look at non-disclosures, I work for a publicly traded company, and when we look at non-disclosures, we have a few issues to consider, primary of which is making sure that folks comply with SEC rules and regulations as far as insider trading goes. There's been a lot in the news about Nancy Pelosi and things like that and how insider trading looks, but we want to make clear to folks who we are disclosing information to that information that we are providing to them is material, non-public information, and that they should not trade on that information. Signing something makes it much more clear to folks that that is actually something that they need to do, rather than just simply stating to them, hey, don't go trade on this. This makes a record, and it shows that they do, in fact, have been told that. The other thing about projects is when we're evaluating a potential site, we want to make sure that it's a location where people want us. We don't choose to go to locations that don't want us. There may be some people there at a location that might not like the project, but we want to make sure that by and large what we're doing is compatible with the lifestyle, the country lifestyle, all of the other things that are brought up regularly, and make sure that it's compatible. In order to do that, we want to be as transparent as humanly possible to the folks who live there and are on these boards and understand these deep-rooted issues that are inside of their communities. By being able to be very open with them what our projects look like, take them on tours of existing sites so that they can really understand it, it allows us to be very open during an initial phase where we're trying to understand, are we compatible? Will this work for this community? And the answer is it may not. If it does not, why get an entire community up in arms, either for or against a project? I've been in projects where I've gone to a committee or I've been out in the open, and I still today, to this day, years later, hear about, hey, when is that project happening? And people have spent a lot of effort really for no reason, because ultimately we chose not to go to that site. This really takes away local control from the locals. If the locals want to pass an ordinance and say, hey, we don't want this, they can do that. They can do that today, right now. This chases away opportunities. It will make others look at South Dakota and look at what South Dakota is up to and say this is non-serious. Other industries, this bill goes after one single industry. There's lots of other industries people would probably like to know about, animal ag, industrial animal ag, hog houses, things like that. Those can all have non-disclosures, but not data centers. We're just looking for an ability to have an open conversation before we get out in the public, because if it turns out it's not a good location, then we can move on. This does not take away openness or transparency. There are no kings of planning and zoning. There are no kings of county commissions. There are no kings of city councils. They don't get to make decisions during this introductory process. There are still public hearings on zoning and ordinances and planning and all of the other things that happen. All of that still happens. It just happens at a time when the project is more serious than at a time when we're just trying to understand, are we compatible or not? Water, noise, energy, all those things still have to go through the exact same processes anyway. I urge you to vote no for this. If you have any questions, I'll stick around for a bit. Thank you for your time.
Thank you, Mr. Phillips. Okay, with that, we got people filing in the back. Just a brief couple minutes, sure.
Thank you, Mr. Chairman. Steve Del Bianco with NetChoice, and I appreciate you giving us just a moment here. I support everything that Mr. Phillips had said about the why non-disclosure agreements make sense, but the proponent discussed that bills like this are floated in multiple states. Those bills are running into the same opposition that you're hearing here today because of the unintended consequences of what seems like an important gesture. Consider this. I have been in local zoning hearings all over this country. The presence of an NDA does not block public participation. It simply blocks premature disclosure of the name of the company. Those public hearings are full of people raising questions about electricity, land use, water use, and all of the other concerns. And all that is missing is the name of the company, who's usually one of my members at netchoice.org. We hold back the name of that company until this project has reached a point of certainty that they're going to go in and try a rezoning, at which point the name of the company is apparent. So the reason they do this is to avoid really upsetting people on both sides of the spectrum. People that didn't want that company to come to their community, and those that really desperately wanted the economic development, jobs, and property tax relief, who are now angry that one of my companies has said, doesn't look like it's going to work out. Thank you, Mr. Chairman.
Okay. Well, with that, I think the chair is going to defer this bill for this afternoon. We're going to plan to reconvene, I believe, in this room 15 minutes after we gavel out from the House floor today, at which time we'll restart taking proponent and opponent on this. So at this time, the chair would entertain a motion to adjourn. Yep. Motion by Gosh, seconded by Overweg to adjourn. All in favor would say aye. Those opposed, no. We are adjourned.
When South Dakotans need reliable information, SDPB is there providing updates and coverage that keep our communities safe and connected. Good, useful, and full of wonder. SDPB. SDPB celebrates South Dakota's student athletes with live coverage of SDHSAA state championships, sharing the excitement of hometown heroes. SDPB. Good, useful, and full of wonder. From choir to debate to theater, SDPB shines a spotlight on South Dakota's talented students through SDHSAA All-State Fine Arts programming. Good, useful, and full of wonder. SDPB. Every day, SDPB connects South Dakotans with stories that inform, inspire, and bring us together. SDPB, good, useful, and full of wonder. SDPB is your home for fact-based journalism, connecting South Dakotans with news they can trust and stories that matter. Good, useful, and full of wonder. SDPB. From children's programs to in-depth documentaries, SDPB sparks curiosity and lifelong learning in every South Dakotan. SDPB. Good, useful, and full of wonder.
Good morning. It's time. It's actually past time to bring the Senate State Affairs Committee to order. I'd like to welcome everybody here today. If you're going to be testifying on a bill, please be sure that you sign in the back of the room. If you have trouble with it, our pages are here to help you kind of navigate the electronics. If you're online listening, welcome. Please keep your self muted until it's time for you to speak if you're planning to testify online. At this time, I will ask the Secretary to please call the roll.
Senator Dybert.
Here.
Jensen.
Here.
Carr. Excused. Kolbeck.
Here.
Larson.
Here.
Pischke.
Here.
Voigt.
Here.
Perry.
Here.
Melhoff.
Here.
Mr. Chairman, we have a quorum.
Thank you. At this time, I'd entertain a motion to approve the minutes from our last meeting.
So moved.
We have a motion by Senator Perry, second by Senator Dybert to approve the minutes. All in favor say aye. Aye. All opposed, same. Motion carried. The minutes are approved. At this time, I would like to take the opportunity to have our pages come forward and introduce themselves. If you could tell us who you are, where you're from, what your plans are, and if you have a joke you would like to tell, you can sure tell it.
Hi, I'm Ada Ryder. I'm from Henry, South Dakota, and that's where I go to school. And currently I'm taking my private pilot's license, and so I plan to go to SDSU to major in aviation. And I don't have any jokes.
I'm Richard Carlson. I am from Harrisburg. I plan to go to USD for secondary English education. What do you call where does a fish keep its money? The riverbank. Well, something I have there in the dome.
That's pretty good. I like it. All right, thank you very much. If you're testifying, you have materials to pass out, please use the pages for that as well. And with that, if you're testifying on behalf of somebody, if you're a lobbyist, please make sure you have your proper badge displayed. And we have quite a bit of work to do today, so I'm going to limit pro and opponent testimony to 12.5 minutes for each bill. That should get us about an hour and 15 minutes of testimony overall and 45 minutes for questions, discussion, and action. So with that, the first bill up is Senate Bill 127, which is an act to limit nuisances caused by data centers. Is there any proponent testimony for 127? Welcome, Senator Howard.
I'm eager. Thank you. Senator Taffy Howard, District 34. So I'm asking for your favorable consideration this morning of Senate Bill 127. It is a measured, community protective approach to data center development in South Dakota. This bill does not oppose technology investment. It simply ensures that these industrial facilities are sited and operated in ways that respect the health, peace, and property rights of our citizens. A critical part of this bill is its 45 decibel noise limit at the nearest property line. To put that into context, 45 decibels is quieter than normal conversation and similar to the ambient sound of a quiet home or library. It also requires a 1 mile setback to any residence or zoned residential area. With both of these, local counties and cities are free to adopt more stringent regulations if they choose. An example in North Dakota, a county there adopted 2 mile setback and 3 miles between data centers. So let's talk briefly about the noise limit. For rural residential protection, 40 to 45 decibels is generally considered the range where sleep disruption starts is reduced. The risk is reduced, I'm sorry. Above 50 decibels at night, complaints become common. Around 55 to 60 decibels, it's usually considered clearly intrusive for a residential setting. So if you're trying to prevent South Dakota from becoming the next data center noise fight, 45 decibels is on the protective end for the health and well-being of our citizens.
Senator Howard?
Yes.
You have an amendment out there.
I
Did you wanna
do,
move
and I
that?
would like to move Amendment 127A.
Too late, you missed the window.
So moved.
We have a motion by Senator Perry, second by Pischke to move Amendment 127A.
Thank you, yes.
Okay, all in favor, say aye. Aye. Opposed, same? Sorry, I meant to remind you of
I
that.
do have
earlier.
3 bills this morning here. So,
Understood. So we were at 45 decibels. Please
thank
continue.
you. Yes, we are. So a New York resident expects constant noise. South Dakota residents do not. For most of our state, nighttime ambient noise may be closer to 20 or 30 decibels. So even 45 decibels from a data center can feel very loud because it is a steady mechanical sound against a silent background. Across the U.S., governments have begun adopting regulatory standards that reflect concerns similar to those in this bill. These quality of life concerns are not hypothetical concerns. Communities are already fighting back when data centers and similar high-intensity computing facilities are built without adequate guardrails. One of the most striking examples is in Hood County, Texas, where residents near a large industrial computing facility have reported a constant mechanical hum and noise that they claim has led to sleep disruption, stress, headaches, and other health concerns. According to reporting, some residents measured noise levels in the range of roughly 35 to 53 decibels at nearby homes, with higher levels closer to the facility. And residents are so frustrated with the lack of enforceable local control that they began pursuing incorporation as a city, specifically to gain authority to regulate the noise. That should be a warning sign to all of us. When government fails to put reasonable standards in place up front, citizens end up forced into lawsuits, moratorium fights, and drastic local action just to protect their basic quality of life. So these examples demonstrate a clear pattern. And you see from your handout, I gave you different examples from other jurisdictions across the nation. Other government entities are recognizing that unfettered data center siting can have real effects on nearby residents. Noise, traffic, strain on infrastructure, and quality of life issues. SB 127 brings South Dakota into this mainstream of responsible planning, not by banning innovation, but by ensuring it happens at a sensible distance with measurable protections like noise limits and setbacks. And importantly, bills like this work hand in hand with any temporary pause or planning effort, because if South Dakota is going to allow hyperscale development moving forward, we should make sure the rules are clear, enforceable, and protective of residents from the start. So in closing, this bill protects property values, the rural character of our state, and the quiet enjoyment of our homes while still allowing responsible infrastructure investment. So I would kindly ask for your support for Senate Bill 127, and I'll stand by for questions.
Thank you, Senator. Further proponent testimony? And I'm going to ask everybody to keep it very sharp and not repeat information, because we have a lot of bills to get through this morning. So welcome.
Good morning, Mr. Chair. I guess it's still morning. Thank you and the committee. My name is Carla Shonsenba. I'm out of Pennington County, and I am in support of SB 127, I guess as amended, an act to limit nuisances caused by data centers. While many of the other 9 or 10 bills that are here in legislation this session, this is the only bill that I am aware of that addresses issues outside utility usage and tax credits. And it is the only bill to look at the impact of noise on surrounding communities. While I'm not sure it's going to see the floor, I certainly hope it is the start of a conversation to look beyond just the resource issues of data centers and make sure that we are looking at these quality of life issues that impact our residents in surrounding areas. And these are things, if you were putting in one data center, I think it would be more likely that you would let those jurisdictions deal with this. But we have data centers being proposed across the state in multiple counties, so I certainly think it's appropriate to put some boundary conditions on this. Also, I have worked as a chemical engineer, and I'm here to tell you that companies can survive regulation. So thank you.
Thank you very much. Further proponent testimony on Senate Bill 127. We're about 6.5 minutes, so there's 6
Good
minutes
morning.
to go.
I'm Florence Thompson Fuller. I represent South Dakota Citizens for Liberty. I have two badges. We do support this bill. We think the amendment really helps the bill, and we think it will protect our property rights and our well-being of our citizens. So thank you for passing this bill to the floor.
Thank you. Further proponent testimony on Senate Bill 127 in the room. If you're planning to testify, try to get nearby so we don't waste a lot of time making our way to the mic. Welcome.
Good morning. My name is Erin Taggart. I am representing myself. I'm from District 2. I just want to be really short. I live a half a mile from this development, so this will truly affect me, the noise. I'm also representing my neighborhood, which is about 270 homes in this area, and future development that there's quite a few empty lots that will be there. So I do support this Bill 127 to protect not only our neighborhood, but all the future neighborhoods that this could possibly affect in the future. Thank you.
Thank you. Further proponent testimony on 127 here in the room. Morning, we're just about to 8 minutes, so we got 4.5 minutes left.
Thank you, Mr. Chair, committee members. My name is John Coonery from District 11, and I'm speaking in favor of this bill, SB 127. And in addition to these noise limits, I think, which are reasonable, we also have to consider, and I know that this bill does not specifically speak to EMF radiation, but I think that you have to consider that, and I think that your people
Please keep your testimony to the bill.
Okay, yes. So please do read what I did share, because also the noise does create frequencies that do have health effects, and what I spoke to in my information I shared speaks to the long-term effects of even low sound that is dissonant to what our bodies can handle, and that does have both health impacts, also psychological and other chemical reactions in our bodies. And so we think that that's very important that you consider that. And I'll leave it at that for this bill. Thank you very much.
Thank you, sir. Further proponent testimony on Senate Bill 127 in the room? I don't see anybody making the, okay. We're about 9.5 minutes in, so.
Good afternoon, Chair and committee. My name is Joseph Whiteeyes. Here as a member of the Cheyenne River Sioux Tribe, but also a member of the National No Data Centers Coalition on Indian lands. I just wanted to drop one fact here that we've got from one of our fact sheets that we helped create. So data centers are able to emit up to 97 decibels of sound pollution, enough to cause permanent hearing loss for people who work or live nearby. This is comparable to the sound of a motorcycle or jackhammer next to your bedroom window. Yes, I just wanted to share that, and I hope you pass this bill. Thank you.
Thank you, sir. Further proponent testimony on 127. I don't see anybody making their way forward, so we will go to proponents online, and we have Luann Lippert, or Lori Lippert, I'm sorry. You are muted right now. Please unmute yourself and continue.
How about that? Can you hear me?
There you go, yes.
Okay, good morning. I'm here in favor of SB 127, the nuisance law. There are many health effects that some have been mentioned and some haven't. The intensified CO2 from all the fossil fuel emissions is definitely a problem. We're talking chronic respiratory illnesses such as COPD, asthma, diminished air quality, and ultimately cancer. The HVAC fans that run approximately 96 decibels do cause hearing damage, and the recommendation for that is 2.5 to 3 miles away. Many of these sites are proposed for much closer to homes and people. There is what was mentioned, a sub-decibel noise from fans and generators. That's up to 2 miles away, registering as pressure in the body rather than decibel measurement, causing vertigo, fatigue, headaches, nausea, hearing loss, sleep disruption, endocrine effects, hypertension, cardiac rhythm issues, and stress. There's evidence of cognitive and learning problems in children, and studies are now starting to look at bone density loss. In the proposed site in Sioux Falls, there's a large daycare near it, several housing developments within 2 miles or less of the proposed site, as well as a healthcare facility and 2 over 55 complexes. The third thing I want to address is the diesel generators. These are a very big problem. On average, a hyperscale data center uses hundreds of shipping container-sized diesel generators on site. They are run regularly to test and continually are run during peak energy times like in the summer and during power outages. They emit toxic pollutants such as benzene, formaldehyde, carbon monoxide, nitrous oxide, and arsenic, most of which are known carcinogens. The noise level of diesel generation is up to 100 decibels, 3 miles away.
Ms. Lippert, the time is up, so I'm going to ask you to please wrap it up, and we'll give the other a chance to meet you.
Oh, okay, I'm sorry. I had a 4-year-old son with brain cancer, and so I've become very alert to health and quality of life issues, and I would respectfully ask you to support this Senate bill. Thank you.
Thank you. And I'll give Brooke Manka, if you're online, if you want to give some very brief testimony, I'll allow it.
Thank you. I am from Spearfish, District 31. I have a background in environmental science from Southern New Hampshire University, so I just also wanted to bring awareness that the noise and light pollution can affect wildlife within our state. So, environmental impact studies to determine any environmental impacts to our local wildlife in particular would also be important, because data centers have shown to create noise and light pollution, and there are links between that and the effects on conservation. And I would just ask that you support this bill and pass this bill. Thank you.
Okay, thank you, Ms. Manka. With that, we will close proponent testimony, and we will move to opponent. We got to 14 minutes, so we went over a little bit, and we'll allow opponent the same amount of time. So we'll begin opponent testimony on Senate Bill 127. Please state your name and begin, sir.
Morning, Mr. Chair, members of the committee. Mike Bockerny, the CEO of the EDPA of South Dakota. We rise this morning in strong opposition to this bill, and I'll keep my comments related to the bill that we are talking about right now. Traditionally, South Dakota has avoided establishing any sort of statewide setback requirements for land uses. That authority has been delegated to counties and municipalities. The approach in this bill does not reflect South Dakota's longstanding commitment to local control, the principle that effective government is one closest to the people. Let's talk about some specifics in this. First, we feel that this bill conflates nuisance and zoning authorities. Why is the state conflating nuisance law with zoning land use regulation? While certain land uses may have the potential to become nuisances, local governments address land use concerns through zoning ordinances rather than through nuisance declarations. This distinction reflected in 21-10, where specific land uses, including agriculture and sports shooting ranges, are protected from nuisance claims if they comply with local zoning regs. Compliance with zoning has traditionally served as the appropriate regulatory benchmark. Second, let's talk about the 1 mile setback. This also can conflict with existing comprehensive plans and zoning. Why 1 mile? What data, study, or regulatory precedent supports this specific distance? The proposal appears arbitrary and opinion-based rather than grounded in objective standard or any sort of demonstrated need. Further, this bill allows local governments to be more restrictive, not less. What happens if a county or municipality has already adopted a comprehensive land use planning and zoning regulation governing this use with less restrictive setbacks? Imposing a more restrictive statewide requirement undermines local planning efforts and directly conflicts with the principle of local control. Third, let's talk about the overbroad definition of residential area. The term residence or residential area could be interpreted to encompass all rural areas of many counties. Depending on population density, this provision could effectively eliminate the development of the proposed use altogether, making it exclusionary in practice and potentially exposing counties or municipalities to litigation. Fourth, let's talk about township zoning authority. This bill implies that townships may possess zoning authority which conflicts with other sections of state law, including 11-2, 11-4, 11-6, and 8-2. This provides for statutory inconsistency and legal confusion. If the state establishes setbacks here, what comes next? Will the state begin prescribing separation distances for other land uses already regulated by counties or cities? This sets a precedent for state-level intrusion into matters that have always been governed at the local level. Extending this logic will erode meaningful local authority over routine land decisions. The state should not establish setbacks for land uses that counties and municipalities are fully capable of regulating for their own citizens. If this legislature wishes to apply standards only in counties or municipalities without zoning authority, that is a totally separate discussion. However, imposing blanket statewide setbacks, particularly while including townships and zoning language, is inconsistent with existing statutes. It undermines South Dakota's commitment to local control, and it creates significant legal and policy concerns. Now, briefly, let's talk about a decibel level as referenced and discussed in Section 3. Where did we come up with 45 decibels? For example, a honking horn is 90 decibels. A grain elevator is approximately the same. Are we going to start legislating all of these items at the state level now? These issues have historically been addressed properly in the past at the local level. This needs to stay at that level. We ask for your opposition to this bill. Thank you.
Thank you. Further opponent testimony on Senate Bill 127. We're about 4 minutes and 20 seconds in, so please be mindful of others who'd like to testify.
Thank you, Mr. Chairman. My name is Steve Del Bianco. I'm the president of NetChoice. That's the National Trade Association of America's tech companies, all of which are listed at netchoice.org. Our companies are not proposing or even investigating data center tracts of land in South Dakota right now. That would only come after the legislature sees fit to amend some of the sales tax statutes to be competitive with North Dakota, Iowa, and other states. You may or may not do that. But if that time should come and South Dakota becomes in the game, becomes competitive, there are communities in South Dakota that are eager to get the investment, the jobs, and the property tax revenue. And those communities with local control have the full authority, as Mr. Bacarny just described, have the local control to assess the right place to put a data center. By the same token, there are suburban and rural areas in South Dakota that probably don't want to have a data center, and your local control allows them to say no. All this bill would do is to tie the hands of a South Dakota county and town that is desperate to create new job opportunities and property tax relief for the people that live there. The definition of residential area includes anything designated or zoned. So when we go in and buy a few hundred acres to have adequate setbacks for noise and sight, our companies will be challenged to find anything that is fully a mile away from a parcel of land that might have been designated for residential. You've got to allow the flexibility at the local level for determining the appropriate setbacks and the appropriate noise, or communities across South Dakota will not be able to take advantage of what has benefited so many communities in North Dakota, Iowa, and other states. Thank you, Mr. Chairman.
Thank you, sir. Further opponent testimony on Senate Bill 127.
Morning, Mr. Chair, members of the committee. My name is Sam Nelson. I'm a registered lobbyist for the South Dakota Municipal Electric Association, and I'm not a cellist, but I wanted to be one. And that's Bach's Cello Prelude. It's one of my favorite pieces for what it's worth. I'll try not to, Mr. Chair, I'll try not to retread the ground that Mr. Bacarny so eloquently covered. But I want to talk a little bit about the arbitrariness of this as it relates to nuisance law. If you look in the book, 2110.1 is where you start to find your nuisance law. And it's got, it tells you under 2110.1 what a nuisance is, and it's something that annoys, injures, or endangers the comfort, repose, health, or safety of others. It offends decently, it unlawfully interferes with, obstructs, etc., use of property. And then when you get to the case law that interprets that, that's pretty broad, and it's broad on purpose because there's a lot of different things people can do that interfere with your use and enjoyment of your property. But when we get to the case law interpretation of it, it talks about generally a nuisance is a condition which substantially invades and unreasonably interferes with another's use, possession, or enjoyment of property. I'd submit to you that this is an unnecessary, arbitrary, and frankly way too expansive definition of what a nuisance is, particularly as it relates to one type of business. The bill says that if you're making a noise louder than 45 decibels, or you're doing anything within a mile of a residence, it's automatically a nuisance. And I want to give you some other pieces of this bill that I think don't make sense when you put them in context. We say that a data center is something that has a 10 megawatt peak. Well, if you look at the Solventum plant in Brookings, that has a 10 megawatt peak use of power. It hits 10 megawatts from time to time. That is well within 1 mile of residences in Brookings, and there's no problem. I wasn't able to find this data, but I can imagine operations inside that building and sometimes adjacent to that building probably exceed 45 decibels on a regular basis. Let's talk a little bit about some decibels for comparison. I was able to find an old DOT study from 2010 that talked about I-29 kind of south of the 41st Street interchange. And it talks about at places at 401 St. James Street, the average, and this is in 2010 by the way, the average decibel usage during the daytime on the interstate was 72 decibels. By the Carrington Apartments, it was 67 decibels, and by the Mayfair Apartments, it was 70 decibels. The DOT standard for noise on the interstate is 67 decibels. And so when we put this into context, 45 doesn't necessarily make sense. The vacuum cleaner that I use to clean my home is about 80 decibels. And so when you look at what this does and what it's applied to, it's simply arbitrary. We heard proponent testimony about things like it's reasonable, rational, et cetera. But if you look at the setbacks on this, you can't build one of these anywhere under the statute if it passes. So we ask you to oppose it. Thank you.
Thank you. Further opponent testimony on Senate Bill 127. We are just about at 10 minutes, so we got 4 minutes remaining.
Morning, Mr. Chairman, members of the committee. It's incredibly disarming to have somebody looking at you from like 6 inches away on the screen here. My name is Drew Duncan. I'm a lawyer from Sioux Falls and the registered lobbyist for Heartland Energy. Heartland provides wholesale electric service to 29 cities and municipal electric systems across South Dakota, Minnesota, Iowa, and Nebraska, many of them smaller communities, which is incredibly important for this bill. We also provide energy solutions to 6 entities here in South Dakota. This bill invites litigation, picks winners and losers in the electric industry by limiting locations for development. It contains overly broad definitions of data centers that catch the kind of projects that most cities would invite. This bill essentially prohibits large project development in most kinds of municipality, takes away from cities the chance to decide project development. As you've heard previously, projects that can bring good jobs and much needed tax revenue to our cities. In other data center bills currently being considered by this legislature, we are saying the state can't preempt any local ordinance or regulations. But in this one, we say the exact opposite. We say we don't trust our local leaders to make the decisions about what is good for their own cities. My client does not think that is good policy. This is especially true in the cities we serve, cities that are not large by any designation. Cities where an existing home is probably less than a mile from everything in town. Simply put, it's a killer to small town development. Section 4 of this bill also invites litigation. It would allow lawyers and litigation speculators to shop for clients who might want to create mischief and stop all development in their communities. We have seen this type of behavior in other recent big projects proposed in South Dakota. But this gives them now a mechanism to create hardships for their cities and the people doing business in their communities. We're going to ask you to please defeat this piece of legislation. Thank you.
Thank you, sir. Further opponent testimony 127. Got about 2 minutes left, so please be respectful of others.
Mr. Chairman, Nick Phillips from Applied Digital. You know, I'm confused here. South Dakota I've spent some time here. It seems that South Dakota is all about local control. This is the opposite. I won't get too much into that. But what I will get into is that I've built these types of facilities in many small locations, and local control has enabled a lot of positive things to happen. We've worked with neighbors continually. There's, in some cases, been places where we've planted trees for neighbors to help them. There's been times where we've agreed not to drive on certain roads. The point is that the locals who know right where this facility is, they understand the area and help us to facilitate conversations with locals and make sure that we are making decisions that are appropriate for that area. Very hard to do from very far away. Additionally, I've done a lot of sound monitoring on the prairie for several years now. 45 decibels is a regular occurrence on the prairie. It's almost never below that sound decibel level. I see in the 50s quite regularly just natural sound noises that are out there. Housing is very confusing also in this definition of how this works here. Pretty much nowhere in South Dakota would be a place that would be eligible to build one of these facilities under this language. And another question I have on this one is, what if somebody starts to build a home concurrent to or just after one of these facilities is starting construction? We proceed with construction over an 18-month to 2-year type of a period, and there's no real definition of what does established mean inside of here. If our facility is established, is it established when we start operations? Is it established when we get a permit, do testing? This is all very confusing. I think that this has not been fully thought out. There's lots of unintended consequences here, and I urge you to vote no on this bill.
Thank you. We have time for one more. Please be brief.
I will be. Thank you, Mr. Chairman. Brett Kennecke, a lawyer from Custer, registered lobbyist for the South Dakota Bankers Association. As I look at this bill, I want to urge you to consider that definitions mean things. and this bill adopts an extraordinarily simple definition of a data center, a centralized repository for the dissemination, management, processing, and storage of electronic data and information. To me, that sounds like a bank or a catalog company or an internet sales, and purchasing provider. There's all hospitals, schools, all kinds of things fit in that definition. And I would submit to you adopting this is a bad idea overall, but to not think about the definition and everybody that's might be included in that, it really shows the fatal flaw in the bill. I'd urge you to not to adopt it. Thank you.
Thank you. We're going to allow Me Too's for anybody else who has signed up and wants to appear in the minutes as an opponent.
Thank you, Mr. Chair. Mitch Rave with the Greater Sioux Falls Chamber of Commerce. I would just echo the comments by the previous speakers and add that I'm wearing an Apple Watch with a decibel reader, and we're well over 45 decibels in this room alone. So with that, we'd urge your opposition. Thanks.
Aaron Scheibe, attorney from Pierre. I represent Clean Grid Alliance, a membership organization of about 50 organizations, entities that are active in the grid and utility space. Me too. It's hard for a lawyer to say just me too, but me too.
I've noticed that. Thank you. Please try.
Mr. Chairman,
Welcome.
members of the committee, Ryan Budmar, South Dakota Chamber of Commerce and Industry. We rise in opposition to this bill. Thank you.
Thank you. I believe that completes our opponent testimony. I don't believe there's any opponents online. So we will close opponent testimony and go to rebuttal.
Thank you, Mr. Chair. Taffy Howard, District 34. Well, I always like it when opponents kind of prove my argument. When the opponents got up here and started pointing out a honking horn is 90 decibels, do you want to sleep next to a honking horn? Can you sleep next to a honking horn? We could talk about all the lawn mowers. I mean, the point here is that these are data centers are facilities that create noise 24/7. And the question you have to ask yourself is, do the people come first in this state, or does money come first? Is that always going to be our top priority? Or are we going to think about the quality of life, the health of our citizens? It is a proven fact that noise level contributes to health issues, whether it's high blood pressure, cardiovascular disease, hearing loss, tinnitus. I could go on. There's proof. So that 45 decibel was not picked out of thin air. It's based on looking around at what is an acceptable level that doesn't disrupt sleep or disrupts it as little as possible. I mean, where I'm staying right now, I do have constant noise. I'm like, on some nights, and I'm like, okay, I am struggling to get some sleep. So it just kind of proved my point. The issue about banks being caught up in this, no, because they're not generating or needing to use 10 megawatts of electricity. So I would dispute that argument. And then the argument about the 1 mile setback might impact the rural areas. Well, do our rural residents not count? Do they not matter? I mean, I was talking to a senator who comes from, a representative who comes from a more rural area, and he has experience with data centers, and he was not going to sign on to this bill unless it was at least a 1 mile setback. So every one of our citizens matters. Their health and well-being matters. Our way of life matters. This is a common sense bill, and I would urge your support. Thank you.
Thank you, Senator Howard. We will now go to committee questions. Are there any questions from the committee? Senator Colbeck.
Senator Howard. I'm just looking at this as a practicality matter. So we'll just take my district. There was a proponent from my district. Where that land is across the street from a power plant, next to a substation, next to a highway, next to where a water tower is going to be built. How would you differentiate the noise from the interstate, the major highway, the Rice Street that's there, a gas station, car wash? How are we going to know that this noise is going to come from a data center?
Well, I would think the first thing you could do is start by measuring the noise level at the boundary of the data center. And then you could do some math. You could figure that out from there. So that's probably maybe above my pay grade, but I know it could be done, because you could figure out what's the noise coming from the interstate, what's the noise coming from here, and you could differentiate from that. And if I could elaborate on that, I actually have a constituent who lives next to an interstate, and when the gentleman pointed out how noisy that is, I literally, to have a conversation with this gentleman in his backyard, I was yelling, and that's not good either. So we have some issues here, but this is just trying to address this issue.
One follow-up.
Go ahead.
And to that point, why would the data center be different then? So we've got as I mentioned, we've got the highway, we've got the power plant, we've got all that. So is it just that your belief is that data center noise is more harmful to your health than other noise?
Go ahead.
This is an attempt to get ahead of the game. This is because we are seeing these industrial facilities coming into our state right now, and the big push is to have them come in. This is really an attempt to go, okay, if you're coming, let's have some common sense guardrails. We can't go back and redo the interstate system and redo what we already have here, but I believe we can lay the groundwork going forward and have some guardrails in place. So that's what this is all about.
Further questions? Senator Perry, then we'll go to Senator Jensen.
This will be for a person that never testified but GOED. I have a question for you, if that's all right.
Mr. Chair, good morning, everyone. Joe Fiala, Deputy Commissioner at the Governor's Office of Economic Development.
Be sure to sign in when you're done.
Sorry to call you into the conversation, but you have a good opinion. I've worked with you through the years, but is this bill going to impede process for data centers? And then the second part of that question would be, with local control, how do you feel about this? Is this over the top, or is this what we need to do?
Mr. Chair. Yeah, thank you for the question, Senator Perry. Questions? To the first question, yes, absolutely. This would inhibit data center development in the state, no doubt. And secondly, I would agree with the opponents that already spoke. South Dakota is a local control state. The best planning happens at the local level. And our counties and our cities already have that ability to do so, and they know their area best. Thank you.
Senator Jensen.
Yes, for Senator Howard. So if a data center were to be built under this restrictions, if a person chose to build a house later across the road, would they still be able to?
The data center would be established, so they would go into that knowing what they're getting into, so, yeah.
Further questions from the committee? Seeing none, we'll close questions and go to committee discussion and/or action. Senator Dybert.
Thank you, Mr. Chairman. A little discussion here. I did some quick math from the center point of the data center. A mile radius is about over 2,000 acres of land they're impacting. So if the data center is the point of the 1 mile setback proposed from the center of the data center, the corners of the building, or the land that it occupies, so that gets exponentially larger. And so now you're impacting people's property rights around you, not just the land you own or where the data center is with a mile setback. So if you read the bill, there's no exclusion for later construction. So now you're taking property rights away from those areas. When you build a data center out in the middle of nowhere, near any type of established municipality, houses are going to go up around it eventually. So you're stealing those property rights from those people. So I think you need to leave it up to local control on the setbacks based on the plan of the specific data center. And on the sound issue, you can mitigate sound with walls. There's other sound mitigation you can do. The local entity, the local government, can determine in that conditional use process or whatever process they have how to mitigate that sound. So I don't like the bill for those reasons. Thank you.
Further comments and/or action? Discussion? Senator Perry.
Thank you. And/or discussion. this would be one of those things that it's important to talk about the sound and are we going to be able to do something? And it's also important to comply with the zoning requirements that are current, but we also have to look at the flexibility in the future and the local control. I think that this is one of those bills that have really brought out a lot of good discussion, but I'm just not sure if this is something that everyone's going to be enthusiastic about.
Further discussion and/or action? Senator Colbeck.
I'll move Senate Bill 127 to the 41st day.
Second.
We have a motion by Colbeck, second by Larson, 41st day. Discussion on the motion.
Yeah, I just think as a practical matter, I mean, we did, and I'll just use the example in my district. You would literally have to stand on a highway at the property line and measure this. And then across the street is owned by the electric company. To the east is owned by the electric company in the state, or the city. And then to the south is actually a landowner who's for the project. So I reject the notion that you can actually tell where the noise is coming from, if it's coming from the highway, the interstate, Rice Street, a gas station, a car wash. So I think the practicality of it is that. Also, I think that the reasonable amount is the local control. And Sioux Falls at a 70 dB for continuous noise and 60 for commercial. So this has already been addressed at a local level.
Further discussion on the motion. Senator Larson.
Thank you, Mr. Chair. Well, I actually appreciate the prime sponsor bringing this because I think that, we don't talk enough about the health effects of noise. That is an actual true fact. However, I think this could be done a little bit differently and not have, it should live in a different place, and it should live in more of the local control and zoning areas. I have an issue with some of the definitions that are used because they make me think that, I just feel like there's a lot more categories of data centers that could fall under that definition that might be unintended, and I do worry about the litigation and as well as inconsistently applying one sound limitation on one type of property and not on another. Like, I'm reminded of the grain dryers that I have been around in my day that are so loud, and those are still there. So I'm going to be voting no on this.
Further comments on the motion? Seeing none, I'll just finish up. I certainly understand the concerns about noise pollution. I used to have my air conditioner compressor was right outside my bedroom window, and when I replaced it, I moved it around the corner, so it's by my neighbor's bedroom window now. And they haven't said a word. So with that, I will ask the secretary to please call the roll. The motion is 41st day by Colbeck, second by Larson.
Senator Dybert.
Aye.
Jensen.
No.
Carr. No. Colbeck.
Yes.
Larson.
Aye.
Pischke. Excused. Voigt.
No.
Perry.
Aye.
Melhoff.
Aye.
Mr. Chairman, we have 5 ayes, 3 nays, 1 excused.
Senate, the motion for 41st day on Senate Bill 127, having received a majority of the votes, is hereby passed, and Senate Bill 127 is lost. We'll move on to the next item, Senate Bill 128, to update provisions related to certain large-use customers of utilities. Do we have proponent of testimony on Senate Bill 128? Welcome back, Senator Howard.
It's me again, Taffy Howard, District 34. This bill, I'm going to say, is a little more complicated. You are going to be getting some handouts. One is a little flow chart.
Senator Howard, would you
Yes.
like to move the amendment on this one?
Yes, thank you. 128B.
Amendment is moved by Senator Perry, second by Senator Jensen. All in favor of the amendment, say aye.
Aye.
Opposed, the same. The amendment is passed. We are now talking about Senate Bill 128 as amended.
Thank you. And you do have a section-by-section explanation, so you can look that over. This is a technical bill, but it addresses a very real issue, which is how South Dakota should handle new, extremely large utility customers, particularly large data centers, without shifting costs onto ordinary ratepayers or risking system reliability. This is targeted. It applies only to new customers established after 1 July of 2026, and it applies only when that customer has contracted demand of at least 2 megawatts and an anticipated peak demand of at least 10 megawatts. At that scale, we're not talking about a normal commercial customer. A 10 megawatt load can require significant infrastructure, substations, upgrades, transmission planning, and if the law is unclear, those costs can be spread quietly across every other utility customer in the state. Other jurisdictions are already responding to the same problem. In Virginia, regulators created a separate rate class specifically for the largest users to better manage the costs and impacts of rapid data center expansion. That shows where this is headed nationally. States and regulators are building structures to ensure large new loads don't distort the system for everyone else. SB 128, as amended, brings those protections into South Dakota law in a straightforward way. First, it requires utilities to create a separate large use customer tariff, ensuring large users pay the incremental costs they cause. Second, it expressly prohibits cost shifting. Utilities may not raise fees or surcharges on ordinary customers to finance infrastructure needed for these large loads. In plain English, that means no hidden subsidies. Third, the bill allows flexibility through negotiated contracts, but only with guardrails, minimum payment commitments, annual reporting, and approval that the contract is in the public interest. Next, it protects reliability. If there's an energy shortage, large use customers must curtail so that residential customers and essential public services come first. And finally, because water is just as important as electricity, this creates protections specifically for data centers: closed-loop cooling, water limits, quarterly reporting, and mandatory reductions during shortages. This bill is not anti-business. It does not ban data centers or large development. It simply ensures that if South Dakota is going to host extremely large utility loads, the rules should be transparent, fair, and protective of ratepayers and communities. So I'd ask for your favorable consideration of 128 as amended. Thank you.
Thank you, Senator Howard. We are about 3 minutes, 20 seconds. Further proponent testimony on Senate Bill 128 here in the room. Again, we'll try to go with 12 and a half minutes for both.
Mr. Chair, Committee, Carla Shonsenbaugh, Pennington County. I just want to divert just briefly when we're talking about local control. The reason we're here is because we're having issues at local control. God bless our county commissioners, but we are finding out as citizens that actually the county commissioners aren't the powerhouse. It is planning and zoning for those that have it. We are unable oftentimes to get to these issues in time, and that is why we are looking to the state to help us with this. I actually had a county commissioner say, well, it sounds to me like you want more regulation, and if you want more regulation, then you better go look at your representatives in the state. So here we are. We're asking you for help here, okay? Local control isn't getting us everything we need. So please don't use that as the end-all be-all to not help us with legislation. And by the way, if it's all about local control, why is it that all of our esteemed lobbyists are sitting here in Pierre? So just a point. As to this bill, Senate Bill 128, an act to update provisions related to certain large use customer of utilities. I am in favor of this bill. It is an attempt again to mitigate issues around the use in our infrastructure development of electricity and water by data centers, but I think it's done in a better way. It looks at large use customers. It doesn't necessarily single out data centers in every issue. So I think this broader category allows for better legislation. It is very detailed. There are some things I can see there that are problems, but I hope they're amendable rather than to just send it to the 41st day. It requires transparent reporting to the public. And interestingly enough, I think probably because Senator Howard is a legislator, where there is additional burden for reporting, she has put a way in to collect those fees to address that issue. Section 8 specifically prioritizes residential and public service demand over the large use customers, and I realize there is some protection in legislation already for that, but I think it is helpful to have it here. So I respectfully ask you to vote do pass as amended, or please try to amend it and bring it to the floor. Thank you.
Thank you. Further proponent testimony on Senate Bill 128. We're at just about 6 minutes, so.
Thank you, Mr. Chair, Committee. John Coonery, District 11. And I was one of those people of probably 300 people that showed up on January 6th at the City Hall in Sioux Falls, one of 65 that testified, and all but a small handful, maybe 4, that we were against it for many of the reasons that you're hearing today, and many you're not hearing. And one of the things is the current developer of that particular data center, when asked where will the water come from, because they have put some restrictions on, and his answer was, we don't know, we might have to truck it in. Now, if somebody is coming to that point where they're getting approval for changes of what can be built there, and they don't know where the water will come from, that's a real problem. And if the city council approved it regardless, then we are appealing to you to protect the people not only of Brandon and Sioux Falls, but wherever else these data centers are going to be built. Water is one thing. Water doesn't have boundaries underground. And so if they plan to drill wells someplace else and pull it out of the water table, that's going to affect people throughout that region. Also electricity. I look to see what other things use the kind of electrical ratings as what this 500 megawatt facility will use. And some of them are much bigger. And I looked at steel mills that use arc furnaces. Steel mills that use arc furnaces use from 30 to 100 megawatts of electricity. So this is actually using from 10 to more times what a steel mill would use. That's heavy industrial. So we are looking to you to put some reasonable restrictions on what can and cannot be approved at the local level, and I thank you.
Thank you, sir. Further proponent testimony on Senate Bill 128.
Thank you, Chairman. My name is Florence Thompson Fuller. I represent South Dakota Citizens for Liberty, and we do support this bill. We need to look ahead to protect the electric rates. I think that it could easily get way out of control if we don't get a handle on this ahead of time. Thank you.
Thank you, Ms. Thompson. Further proponent testimony on Senate Bill 128. We're just about to 9 minutes. So we've got 3.5 minutes remaining, so please be respectful of others who would like to testify. Welcome.
Hi, my name is Suzanne Pratt. I'm from Sioux Falls. I just have a quick statement to make. Oftentimes in many communities where we see these rate hikes due to communities having to pay for the infrastructure for these large operations to move in, we're seeing double, triple, and quadruple the bills of what they had previously. So one thing that we're hearing over and over is that these data centers can offer property tax relief in regards to our property taxes. So listening to that and then hearing that our utility bills can increase by sometimes quadruple the amount, that kind of feels like robbing Peter to pay Paul to me, and possibly paying more than what we were before if we were to get property tax relief. So I would urge you to consider the large picture of how all of these facets fit into the big picture, and to consider how it affects communities on an intrinsic level. Thank you.
Thank you. Further proponent testimony on Senate Bill 128 here in the room. I don't see anybody moving towards the mic, so we will go to proponent online. Lori Lippert, are you prepared to testify at this time?
Thank you, Mr. Chairman. I also am in favor of Senate Bill 128 to curb the energy costs for homeowners. I don't believe homeowners should be subsidizing billionaires. And they need to pay their own energy costs, and they need to have that in writing with contract upfront. I think that this bill, which is, yes, complicated, also speaks to transparency. There's lots of things in this bill that force more transparency than most of these data centers are showing so far. And this is a problem. The energy costs and the transfer of the cost to the people is a problem across the country. This is something that's well documented and that hyperscale data centers seem to be notorious for. And I think that this bill is well worth putting into place in order to protect South Dakotans. Thank you.
Thank you. Brooke Manka, would you like to testify at this time?
I think this was covered well by the others, and I just want to say me too.
Okay. Thank you very much. At this time, we'll close proponent testimony to Senate Bill 128, and we will move to opponent testimony. And again, we're limiting time to 12 and a half minutes for pro and O. So please proceed.
Morning, Mr. Chair, members of the committee. Mike Bockerny, CEO of the EDPA of South Dakota. We rise in opposition to this bill this morning. I do have to give Senator Howard some credit. There are some pieces in this bill that make sense, but there's some other bills that are out there that I think are framed a little bit better. I'm going to talk about the issues with this particular bill and why we feel this one needs to go away. We've heard a lot of comments thus far about all of these concerns, issues with potential increased costs being passed on to the other folks. I would submit to you, we have a number of users across the state of South Dakota right now that come in and need all kinds of additional infrastructure brought into their businesses, into their industrial operations. Can anybody point to us an issue that we've had over the last 50 years when these have been brought in, where these costs have been passed on to consumers across our state right now? Nobody's brought that up. It was all the opponent testimony keeps referring to data centers. This bill is not specific to data centers. It opens up to any potential business as long as you're going to pull 2 megawatts or greater. There are a number of businesses like that exist right now. What happens when they expand? Have they been bad operators? Have we had any issues from them? Nobody can point to us an example where we've had those issues. So if we're worried about data centers, we need a bill specific to data centers, not just this. Okay, I'm sure that you will hear from Mr. Del Bianco and Mr. Phillips that there are numerous data points out there that when data centers come in, you actually drive down the cost of electricity. I will leave that to them. I also want to point out, and this was just essentially glossed over in the testimony thus far, is this bill mandates what's called a closed loop cooling system. This doesn't really have anything to do with electricity. This has to do with water usage. All we're talking about thus far has been the electrical usage. When you start mandating a specific system, in principle, that sounds responsible, but it substitutes legislative design preference for engineering optimization. In our climate here in South Dakota, certain operators may choose to use a different system that might reduce both water consumption and electricity demand. When you put something like this in statute, it could effectively eliminate a better opportunity, a new technology in the future. So if we're mandating this technology, which is a great technology, that should be handled on the local level, not at the state level. This is the same conversation as we just had. We need to let this stuff happen at the local level, and when things evolve and get better, we're able to enhance our operations for this, and I'm sure what others are going to lay down too. We just ask for your opposition to this bill. Thank you.
Thank you. Further opponent testimony on Senate Bill 128. We are at 3.5 minutes.
Thank you, Mr. Chairman. Steve Del Bianco, the CEO of NetChoice, and Paige is distributing a simple handout so that I can pick up on Mr. Picorni's point on electricity rates and encourage you to oppose this legislation. The Trump administration and Department of Energy did a detailed study of the 5-year period from 2019 to 2024 on what has happened to retail electricity rates paid by people like you and me in every state. And they particularly concluded that utilities end up reducing electricity rates for regular payers if they have a large load data center that absorbs more of their fixed costs. And Washington Post put it best when they evaluated the Department of Energy study and said, quote, "There's a reason electricity prices have been rising, and it's not data centers." The best example is Virginia, where I live, the largest concentration of data centers in the world. Beijing is number 2, and they're a distant second. According to the Berkeley Labs Department of Energy study, our demand for electricity where I live grew 15% over those 5 years, while data centers are coming online, and that growth in data center kept electricity rates lower, flat on a nominal basis, declining under adjusted for inflation. So they concluded that while there have been prices increase in Virginia, the notes that the increase is driven by the state's environmental regulations and an increase in the price of fuel due to global events such as the Ukraine-Russian war. So the experience is clear. The record shows that large load customers like data centers absorb more of the fixed costs and reduce the rates the rest of us pay. Having said that, my industry is fully committed to bearing the full cost, the full incremental and operating costs of any electrical or water consumption that we do. And large load tariffs, akin to what has been described in this legislation, are appropriate, and our members support them. This legislation, however, prescribes a technology for cooling and a curtailment impulse that make them inferior to 2 bills you'll consider this afternoon that we would interested to talk to you about then. Thank you, Mr. Chairman.
Thank you, sir. Further opponent testimony on Senate Bill 128. We're just about to 6 minutes, almost half.
Mr. Chairman, Nick Phillips for Applied Digital, again on this unofficial data center day. So there's a few issues that I have with this bill in particular. It does, as mentioned before, require certain technology that stifles innovation. If you want to limit something, it should be the consumption, not the specific technology itself. There are 2 bills, though, that are going to be heard later today in this committee that are much cleaner and more widely discussed. We certainly support those topics and look forward to that conversation. This bill also enters the realm of both the PUC as well as the RTOs that already exist. They're creating requirements that are already handling there. And what we are doing under those current and existing things have actually reduced costs for ratepayers. Steve earlier talked about what's going on in Virginia, much closer here in next to us in North Dakota. Our Ellendale project has actually resulted in $31 million in rate reductions to consumers that are customers of MDU in that state, and $1 million of reductions to ratepayers here in South Dakota as a direct result of our single individual project because of the costs that we pay. We're effectively subsidizing other ratepayers, definitely not the other way around. Additionally, what we're doing on the tax side of things, we are also subsidizing there by paying an outsized amount of property tax and other fees and for the services that we do. So I think that this just goes too far. This has things that just stifle innovation and just don't really make any sense. I urge you to vote no on this bill.
Thank you, sir. Further opponent testimony on Senate Bill 128.
Good morning again, Mr. Chairman. Brett Kennecke, a lawyer from Custer and a registered lobbyist for the South Dakota Electric Utility Companies, the investor-owned utilities. I'm going to talk again briefly about definitions. This bill tries to do a number of things, and I would submit to you it doesn't accomplish anything of what it's been told to you by the proponents. But we're taking definitions from the electrical chapter and then we're taking them over to the water chapter and moving them around, and we were adjusting definitions of what a large use customer is. All of that represents legislative determinations that have been made by previous legislatures and upon which people have depended. Customers have depended on those definitions to have their rates and their service and their ability to operate their business and live in their homes. And those systems have evolved, and they're an entire system. There's a grid that involves the transmission and the generation and the distribution, and that's how rates are made and how service is delivered and reliability is achieved. And if we start taking those definitions and moving them around, then all of those investment decisions that have been made in the past are going to come into question. And I would submit to you, if you think there's an outcry about data centers, let's have an outcry about people's electric service and rates. I urge you to be very cautious about what we're doing in this system. Section 56, for example, is discussed in Section 5 of this bill. Section 56 of the Electric Code is a very finely crafted balancing of interests that has served South Dakota for 50-some years, and we're trying to mess with that in this bill for the detriment of one facet of service, data centers, but that also affects things like the mine at Lead. It affects the universities. It affects large users all across the state. And so I would urge you to put this bill to the side. This is not going to accomplish good. In fact, it's going to be the opposite. Thank you.
Thank you. Further opponent testimony. We are just about to 10 minutes, so we got 2.5 minutes remaining.
I'll be quick here. Thank you, Mr. Chairman, members of the committee. Ryan Budmeyer, South Dakota Chamber of Commerce and Industry. We rise in opposition to this bill, just as we would for any livestock operation, egg production facility, manufacturing plant. We ask that you not single out a single industry or pick winners and losers, but this also could have unintended consequences in other industries as well. So for those reasons and all the previous, we ask you to oppose Senate Bill 128. Thank you.
Thank you, Mr. Budmeyer. Further opponent testimony, 128.
Good morning, Mr. Chair, members of the committee. My name is Kyle Peters, and I represent Gemini Family Office, which is the proposed data center site right outside of Sioux Falls, in between Sioux Falls and Brandon. And there's a couple things I want to just go through here quickly and answer some questions that you guys probably have about Gemini. Gemini is a development company. They are not a hyperscaler. They have no data to store. They are developers, very similar to what you hear about people in the state going out and rezoning land and getting a site ready for an industry to come. And so as part of that, the development process is a multi-step process. And, you know, there's some things in this bill that we don't disagree with, but we work with the locals on a daily basis to make sure that this site is compatible for a data center. So as part of that, you know, the rezone process that we went through has caught a lot of attention, but that's one step of many that we have to go through. And I've heard some concerns about water usage. That's step number 2. There's multi-step process here to make sure we can even build a data center, and that also is not to mention some of the sales tax components that we're working on as well. So we rise in opposition of this for many reasons. We think that there's better legislation coming a little bit this afternoon, and thank you for your time.
Thank you. Further opponent testimony. Welcome back, Councilor.
Mr. Chairman, members of the committee, Aaron Scheibe, lawyer from Pierre, Clean Grid Alliance. We rise in opposition to this as well for the reasons you've already heard, so I will keep this short and say me too. I can read the room.
Thank you, sir. Further opponent testimony? You got about 28 seconds, my friend.
Mr. Chair, members of the committee, Mitch Rave with the Greater Sioux Falls Chamber of Commerce. Very briefly, local control gets mentioned in this building every day, and it seems that a handful of legislators want to undermine local control when the locals don't agree with them. And I think that that's bad precedent and bad policy to do at this level. They are the folks that do the blocking and tackling every day and know their communities and how best to regulate them. So with that, we'd urge your opposition. Thank you.
Thank you. I see we have one more, and there's like a second and a half left. Ooh, it's gone. Sorry.
Good morning, Mr. Chair, members of the committee. I will apologize in advance. I'm the victim of some capital crud here, so I apologize for my voice. My name is Darla Pullman Rogers. I'm a registered lobbyist for the South Dakota Rural Electric Association. The South Dakota Rural Electric Association has 35 member companies that provide electricity throughout the state of South Dakota. And as electric utility providers, we concur in particular with the comments of Mr. Kennecke on behalf of the South Dakota Electric Association. So we will say me too at this time. Thank you.
Thank you. I believe that concludes all of our opponent testimony, so we will go to rebuttal. Welcome back, Senator Howard.
Thank you, Mr. Chair. You know, it's always really interesting to listen to the opponents because a couple of them just contradicted themselves. On the one hand, we don't like that it's for all large use customers and it should just be for data centers. But then on the other hand, we can't pick winners and losers and we can't just single out data centers. So which is it? This was specifically done for all large use customers. We aren't attacking data centers. We aren't going after them. What we are saying is that if you are a large use customer, regardless of who you are, you should not be passing that cost, any costs related to your business, onto the other customers. This bill has been through a process, I will tell you that, and we do have, so it started out though, probably more targeted towards data centers, but then the issue was, well, why are we singling out just data centers? So we are not singling out data centers on the electricity usage. The water fit into the bill. I mean, the question was, is this a single topic? Yes, it's a single topic. We went through that at LRC, so we put the water in here as well. And that is requiring a closed loop system for water. That is the most up-to-date technology that we have. A closed loop system, just so you know, uses 90 to 95% less water. Okay, so an open system, you're using millions of gallons per day. Closed loop requires 90 to 95% less water. Now, East River may not be struggling for water. West River is. You guys know, you hear that every year. We need a pipeline going West River. So that needs to be taken care of, and I would ask for you to think about that. And as far as if new technology comes along, well, how many bills do we hear every year that we're simply updating regulations? We're just updating a date. I mean, it's very, very easy if some new technology comes along that would actually use less water than a closed loop system, and we wanted to mandate that, then great. That would be an easy enough fix. And then, you know, if electric rates are not rising due to data centers, then they have nothing to fear from this bill. So I don't understand that either. So I'm asking, as you consider this, that I hope you'll choose to listen to the citizens who came up and asked you to vote in favor of this versus the out-of-state lobbyists. So thank you.
Thank you, Senator Howard. We'll close rebuttal and go to committee questions. Are there any questions? Senator Jensen.
Yeah, this would be for Senator Howard. And I apologize if I missed it. But did you run this by the PUC before you brought it?
Thank you, Mr. Chair. I have asked them to look at this several times to give me some input, see if there were things that I didn't have technically correct. I mean, because you know we do have LRC drafting these, and I think they do a phenomenal job. But I did want to make sure that we had everything correct, and so yes.
Further questions? Any questions from the committee? Okay, Senator Colbeck.
For Senator Howard. And I might just be confused, so I need your help here, but in the first page of the bill, it says a large use customer as defined in 4934.1, and then I go to 4934.1. I don't see large use customer in the definition.
Mr. Chair, can I ask, can you tell me what section you're looking at?
So, of your bill,
Mm-hmm.
a large use customer, page 1 there, as defined in 4934A-1. Then I go to the codified law, 4934A-1, and I go into definitions. I don't see large use.
And Mr. Chair, there was some. I'm sorry. We did move all the definitions into section 3. So, yeah. We did clean up the definition section. And section 2 is just updating a cross-reference, so there's nothing there. But you'll see in section 3 where large use customer is.
Okay, so that's where my confusion was. And then, as far as the megawatts, the 2 to 11, it's just my opinion that that's not a large use customer. Do you know where those numbers came from?
Mr. Chair. So PUC already uses 2 megawatts for when you can have an outside contract, and I may not be saying that correctly, but Senator Colbeck, you could probably answer that. But so 2 megawatts is where you can go outside and get a separate contract. As far as the large use customer, that's where the 10 megawatts comes in. So that's where we're requiring that you can't push costs onto other customers. But they can also go out and get a separate contract as well. So there is a difference in, yeah.
Further questions from the committee?
One last one.
All right.
Over the history, some of this stuff was written in 1975. Have you seen a problem? I mean, what is the problem we're fixing? You know, we get a lot of bills and we try to say, this is the problem, this is the solution, and this is why. So I would like you to maybe expound on that.
Mr. Chair. We haven't had data centers. Sioux Falls, we're getting the first hyperscale data center coming in. So this is not an issue that we've had in regards to data centers. And then the issue, somebody mentioned that electric rates we haven't seen an increase. Well, we haven't been keeping track. I would argue that how much lower would our electric rates be if this had been in place 50 years ago? So we just don't have that data. I will say we're seeing issues around the rest of the country. I mean, absolutely, people are, I know in Georgia their rates have tripled due to data centers. But again, we didn't want to pick on anyone here. We're saying any large use customer, if you're building substations and building on infrastructure, you can't pass those costs on to everyone else. So.
Further questions? Go ahead.
This is for someone in the room.
Okay.
You know, if you sit in a room, that's what it is. But I was listening to Commissioner Chris Nelson. He had some appropriations testimony, and he gave some statistics. And I was wondering if he would come up and give those quick statistics. And I can rephrase the question, too.
What are you
Mr.
doing
Chairman,
listening to appropriations?
Members of the committee, Chris Nelson, Chair of the Public Utilities Commission. Yeah, we had a long approach hearing, so if you could tell me exactly where you'd like me to.
So you had if we don't change this legislation, we will stay with the status quo. The status quo, as I understand it, and from your testimony, it's like inflation has gone up 20%, and electric rates in South Dakota have only risen 10 in the last 20 years, or something like that.
If I might, Mr. Chairman, you've got a great memory. So the factoid that I shared was over the last 6 years, general inflation has gone up 26%. Electricity rates for the IOUs that we regulate have gone up 10%. And so the PUC, working with our investor-owned utilities, has done a great job over the last 6 years to keep rates much lower than general inflation.
That's what I was getting at. Thank you.
Any further questions from the committee? Seeing none, we'll close questions and go to discussion and/or action. Is there any discussion? Senator Colbeck.
I'm going to move Senate Bill 128 to the 41st day.
Second.
We have a 41st day motion from Senator Colbeck, second by Senator Dybert. Discussion on the motion.
Yeah, I think, as the good Senator Howard knows, I've been intimately involved in rates and utilities for the last 30 years, and with the facts and the figures, it's just not matching up. I understand the concerns about rates, but when we compare to Virginia, Virginia has 561 data centers, and they actually do not have vertically integrated utilities like we do. They actually put their generation out to bid about 25 years ago, which was a colossal mistake. Georgia, same thing. Different energy grids do different things, and we can just look to North Dakota and see where rates are declining. We can look to Iowa, 4 of the largest data centers in America. Rates have held stable for over a decade. So with that, I think we're good. I think our legislation is solid.
Further comments on the motion? Seeing none, I'll just make a comment. I went over this bill. I have a little bit of history. I worked at the PUC for a while. Albi, I was the grain man, but I also spent quite a bit of time as a city commissioner, as a utility commissioner. And one of our largest loads was the hospital. And if you look at medical centers, there's very few medical centers, large ones, that don't eclipse that 10 megawatt threshold. So for those reasons, I'm going to support the motion. So we have a 41st day motion by Senator Colbeck, second by Senator Dybert. Please call the roll.
Senator Dybert.
Aye.
Jensen.
No.
Carr. No. Colbeck.
Aye.
Larson.
Aye.
Pischke excused. Voigt.
No.
Perry.
Aye.
Melhoff.
Aye.
Mr. Chairman, we have 5 ayes, 3 nays, 1 excused.
The 41st day motion, having received a majority of the votes, is hereby declared passed, and Senate Bill 128 is lost. Move on to our next item, which is Senate Bill 135, to protect residents from increased utility costs and utility shortages caused by data centers and clarify authority to regulate data centers. Do we have any proponent testimony on Senate Bill 135? Again, we're going to stick with our 12.5 pro and O. So please keep that in mind as you testify.
All right. Thank you, Mr. Chair. Good morning. My name is Chris Carr. I'm Senator representing District 11. It's my honor to be in front of you today presenting Senate Bill 135, known as the Data Center Bill of Rights for Citizens. The purpose of this is to protect our South Dakota residents from higher utility costs, water shortages, loss of local control caused by hyperscale data centers. This ensures responsible growth without the hidden costs to families and communities. It puts South Dakota families, ratepayers, and communities first. We know that data centers are among the most energy-intensive facilities in the world. This bill seeks to guarantee that residential customers will not be forced to subsidize data centers through rate increases or cost shifting. It also recognizes local control. Decisions about siting, scale, remain local and not mandated by the state. This also talks about one of our other precious resources, water. We know it's finite and essential. Data centers must demonstrate the compatibility with local water supplies. So for the sake of time, I'm just going to briefly walk through a couple of the sections. Section 1 and 2 really just, I'm looking for my copy of the bill. Section 2 defines data center. Section 3 requires that data center operators to pay all costs associated with the provisions of electricity, so utilities and subsidized data centers, or allocate any generation, transmission, or distribution costs attributed to data centers to the residential customers. Those are protections regarding the electricity. Section 4 protects local control. It prohibits the state preemption of counties, municipalities, other political subdivisions, in regulating, restricting, prohibiting construction, development, or operation of data centers. Section 5 is regarding the tax incentives for data centers. It says the state or any political subdivision of the state may not authorize or grant any tax exemption to a data center. So what that does do, basically, it says no sales tax exemption. However, it does allow the other tax incentives that are already being used and can be used, like the rebate, to be used for these situations. It allows the local tax incentives to be used other than a tax exemption. And finally, section 6, 7, and 8 talks about protecting water. So before operating, a data center must notify local water providers of projected water usage, obtain written determinations that the use is compatible with our water supply, and submit those to the Board of Water Management. I know there's others that want to testify. I'll stand by for questions. Thank you very much.
Thank you, Senator Carr. Further proponent testimony on Senate Bill 135. Mr. Speaker, welcome.
Thank you, Mr. Chairman. Members of the Senate State Affairs Committee, my name is John Hanson, Speaker of the House, representative of District 25, and it's an honor to be here to testify in favor of Senate Bill 135. And I think Senator Carr did an excellent job of summarizing, outlining this particular piece of legislation. You know, one of the things that I'll just highlight is really the rationale behind it. You know, why we're here talking in particular about this issue. Of course, you all know that it's been a massive topic of conversation. There has been a lot of concern, particularly in this last year, that has developed from citizens in South Dakota and across the country when it comes to data centers essentially paying their own way and ensuring that data centers are paying their own way. That ratepayers, when it comes to their electric utility bills, aren't forced to subsidize data centers through higher utility bills, through higher electric bills. That water resources in our local communities are protected. And I think, you know, that's exactly what this bill is getting to. When it comes particularly to data centers paying their own way, just a couple of things that I'll highlight for the benefit of the committee is, you know, data centers, I think, and if you look at AI in particular, they're being developed by some of the wealthiest companies in the world. And I think if you consider the upside, the potential upside to the development of artificial intelligence, it's almost unquantifiable. It's impossible to predict the disruptive nature, not necessarily in a bad way, but that's going to come with AI. I mean, everything from workforce to the development of major motion pictures and everything in between could be taken over in part by artificial intelligence. And so the profit upside to that is potentially monumental. So we're dealing with some of the world's wealthiest companies, and we're dealing with a potential profit upside for them, good for them, that's unquantifiable. It could be so massive. And so the question is, in a lot of people's mind, why would we feel the need to subsidize that if they're some of the wealthiest companies with the biggest potential profit upside? And I think that's a legitimate question, and I think that's part of what this measure is getting to. If you look at, I just pulled today the largest companies by market cap. Number 1, NVIDIA. Number 2, Apple. 3, Alphabet, which is Google. 4, Microsoft. 5, Amazon. 8, Meta. 10, Tesla, all of which are developing, the leaders predominantly in artificial intelligence. Some of the wealthiest companies in the world. And so the question is, why should we feel the need to subsidize that? I don't think we do, and I think that the people of this state want protections to make sure that they're not forced to subsidize that through higher utility bills. That's exactly what Senate Bill 135 is trying to do. And I'll just end with this, and that is, you know, obviously this has been a large topic of conversation at the federal level as well. And I would just want to share with you what the President of the United States most recently weighed in on this issue. And he said this, he said, "I never want Americans to pay higher electric bills because of data centers. Therefore, my administration is working with major American technology companies to secure their commitment to the American people. We'll have much to announce in the coming weeks. First up is Microsoft, who my team has been working with, and we will make major changes beginning this week to ensure that Americans don't pick up the tab for their power consumption in the form of paying higher utility bills. We are the hottest country in the world, number 1 in AI data centers. Data centers are key to that boom and keeping America free and secure, but the big technology companies who build them must pay their own way." That's exactly what we're trying to do with Senate Bill 135, and so we would appreciate your support of this piece of legislation. Thank you, Mr. Chairman.
Thank you, Mr. Speaker. Further proponent testimony on Senate Bill 135. Would have been better if you could actually got the president here, but thank you for your testimony.
Thank you, Chair and Committee. My name is Joseph Whiteeyes. I'm a citizen of the Cheyenne River Sioux Tribe and a member of the National No Data Centers on Indian Land Coalition. I support SB 135 With promises to revolutionize the tech industry, the lack of both oversight and regulations not in place, seen all throughout the country, have allowed these million and billion-dollar data center companies to run rampant. These companies are losing in large urban areas and think we are ripe for picking. We are not. Without certain regulations to energy costs, water consumption, tax incentives, or exemptions, land usage, and environmental impacts, we are ultimately endangering the health and the well-being of both state citizens and tribal citizens of the 9 tribes located here in South Dakota. In many cases, we are seeing energy shifts within our power grids to implement nuclear energy across the nation to support these data centers under the false guise of an energy emergency. This usually leaves costs on the ratepayers with spikes up to 267% in electrical bills. These are found hidden within NDAs between data center companies and power utilities. Water usage for these data centers have caused many wells, lakes, streams, and rivers across the country to dry up or be left poisoned because of the lack of oversight and regulations not in place both for the usage and or discharge of waters for such projects. In the Southwest region, we are already seeing these impacts to certain limited water resources in the area. There have been links to rare cancers because of these water discharges into public waterways, also releasing what is called PFAS, or forever chemicals, coming off of the GPU units housed within data centers, as seen in Ohio. These same companies with millions and billions of dollars attached to them have millions and billions of dollars attached to them, so there's no need for these data centers to have any sort of tax exemption in our state. We are farmers, we are ranchers, we are your neighbors, we are tribal citizens who steward these lands, who care about our freedom and resources. This is the most basic act we can put into effect for protections of our state's future generations. I urge you members of the Senate committee to pass this. Thank you.
Thank you. Further proponent testimony on Senate Bill 135, and I would remind you we're at 10 minutes and we're going to 12 and a half.
Thank you, Mr. Chairman. I'm Florence Thompson Fuller, representing South Dakota Citizens for Liberty. I think the subject's been well covered. There's clearly no reason to subsidize these wealthy companies. So please support this bill. Thank you.
Thank you. Further proponent testimony, Senate Bill 135.
Good morning, Mr. Chair and committee members. Melissa McCauley, registered lobbyist for Dakota Rural Action. We're here today on behalf of supporting this bill. South Dakota is seeking increased investment from large data center developments. We understand that economic development matters, jobs matter, investment matters, but we also understand that rural communities, family farms, small towns, and people who already live there matter. This bill puts reasonable guardrails in place. The legislation makes clear data centers must pay their own way. It protects residential communities from rate increases tied to large-scale industrial load. It's just a fair bill. This also addresses water use transparency in a state where agricultural, ranching, and small community depends on reliable water access. It's reasonable to require advanced disclosure and confirmation of local supplies that can on demand. This bill does not ban data centers. It does not block economic growth. It simply ensures that growth does not come at the expense of rural ratepayers, local water systems, and community decision making. And with that, we urge you to support this bill.
Further proponent testimony. We're just about to 12 minutes. So.
Carla Schanzenbach, Pennington County. I think the best part of this bill is the part where you don't allow subsidies for the sales tax. And I think looking at the similarity of the bill that's going to be out there this afternoon, I would ask that you do pass this and make sure both of those bills can be compared together. Thank you.
Further proponent testimony. We're just about to the Me Too stage of proponent testimony.
Thank you, Chair, and thank you, members of the committee. Janet Jensen, Rapid City. I just want to note that I've been listening to committee this morning, and as I listened to the testimony, I've noticed that the proponent testimony tends to be the people, the citizens, the small businesses. When I listen to who's testifying in opposition to the bills, I see a lot of lobbyists for corporations, corporatists, that type of thing. So I'm asking you today to remember that we are a citizen-led legislature, and the legislative branch does represent the voice of the people. So I would ask you to vote yes on this bill. Thank you.
Okay, we are at Me Too stage.
Sarah Stever, Lennox, South Dakota. I'm a Me Too because of local control and responsible data center development. Thank you.
Thank you. If you'll just please line up so we can get this done. Thank you.
Mr. Chair, John Coonery, District 11, Me Too on for the reasons already given.
Thank you.
Mr. Chair, Chris David, District 13, and it is a local control. People did their due diligence with that. Legislator told us only the angry show up, and so this is why we're at this point right now.
Thank you. We're at Me Too stage.
Susie Pratt, Me Too.
Thank you.
Erin Taggart, District 2, Me Too. And I also would like Senator Colbeck, he is from my representative, to listen to the people
Thank you.
of Brandon. Thank you.
Yes.
Dennis Osmuth, Me Too.
Thank you, sir. And we have one online, Lori Lippert. If you would like to get on the record as a Me Too and reflect it in the notes.
Yes, Me Too. And I do want to say that there is a role for state government in this, so please protect the people.
Thank you very much. So at this time, we will close proponent testimony. We're at 14 minutes and 25 seconds, and we will allow the same for opponents. So opponent testifiers for Senate Bill 135. Welcome.
Morning, Mr. Chair, members of the committee. Mike Bockerney, CEO of the EDPA of South Dakota. Before I get into my testimony, I would like to point out one thing. It was just raised by one of the opponents that you should be listening to the local people. EDPA has over 200 members, all South Dakotans, all of us, every single one. We represent businesses and people across the entire state. Have to give Senator Carr and Representative Hansen some credit here. There are a lot of provisions in this bill that are pretty good. It just has one section that is we feel is has a pretty significant flaw, and I want to talk about that. It emanates from the definition of any political subdivision of the state and how that might be applied. It's mentioned briefly in Section 4, but I'm talking about Section 5. We feel this could extend beyond cities and counties to include townships, road districts, fire districts, school districts, ambulance districts, and a whole host of other districts. As written, this bill could be construed as granting zoning or land use authority to these other political subdivisions, potentially allowing one subdivision to exert authority over another. That is a significant departure from South Dakota's traditional zoning framework, where land use authority is clearly vested in the governing body with jurisdiction over the property. Quite simply, this bill introduces some ambiguity that could result in overlapping authority, intergovernmental conflict, and uncertainty for property owners and employers. We certainly have talked a lot about local control this morning, and we want to be very cognizant of that in any advancing legislation that potentially could redistribute this local control among overlapping governmental units. The other issue and challenge we have with this is why is the state, if we're about local control, telling a municipality they can't do a sales tax deal with the data center if they want to? That should be up to the locals. If they want to exempt them at the local level, let them deal with that. Bottom line is, if a county or municipality does not want one of these, it should be up to them, period. Local control is best. Leave the control up to the locals. For this reason, we oppose this bill. Thank you.
Further opponent testimony on Senate Bill 135.
Nick Phillips from Applied Digital. As mentioned earlier, there are, I think, adequate protections, some of which are actually in this bill, and I would concur with Mr. Bockerney that these are actually decent, except for Section 5, which is prohibiting the it was very interesting to me to hear from one of the proponents of the bill to advocate for the redistribution of wealth. That was quite interesting. But this is not a subsidy. I think that there's some confusion about what a subsidy is. The state isn't giving something it has to a data center in terms of a sales tax exemption or anything like that. This isn't that. But the free market has spoken. We're not here. We are not in this state. We are not building in this state. In fact, after the last testimony that I had in House State Affairs just a few weeks ago, I left this state and went to another state, North Dakota, where we started yet another project, the third such project in the past 12 months that is not in South Dakota because we've been unable to build here and are unable to get a customer to do so. We do pay our own way. We actually pay more than our own way. We actually subsidize the other customers of the utilities on which we operate. $31 million to date in North Dakota for MDU's ratepayers, $1 million to date for MDU's South Dakota customers as a direct result of our project. We'd love to be here, but in order to be here, this state has to be competitive with almost every single other state in the country that doesn't force us to pay these sales taxes, and prohibiting an exemption means we're just not coming.
Further opponent testimony on Senate Bill 135.
Good morning again, Mr. Chairman. Brett Kennecke from Custer, a lawyer and registered lobbyist for the investor-owned utilities in South Dakota. I'm sent up here every day because the people that are members of this organization are home keeping the lights on. And this bill, again, definitions mean things. Data center, to me, means a university, a school, the mine, banks, a number of institutions could easily meet the definition of data center, which is contained in this bill. And I'm up here specifically for the electric utilities. In my day job, I represent utilities down in front of the Public Utilities Commission, and specifically in things called rate cases. And in rate cases, we have a maxim that's called cost causer pays. The people that send me up here want you to know that they agree with you that the cost causer should pay for its use and what its intrusion is on the system that's already operating for the benefit of others. However, data centers are extremely large users of electricity. In some cases, they can be 2 or 3 times the size of the existing operation. And to segregate all of the costs to one customer of that size would be extremely difficult, if not impossible. This bill says all costs. And if you're 1/2 to 3/4 of the electric load of an entire system, how do you segregate all those costs? That's extremely difficult. And if you can't do that, what does this bill do? It pushes people who are operating at this level to generate their own electricity, right? To set up their own electrical provisions so that they're taking care of themselves. And if that's the result of this bill, then the demonstrated benefits that we've seen in North Dakota that flow to MDU ratepayers from that data center aren't going to flow back to your constituents and their customers. So I'm rising in opposition to Section 3. I'm telling you I can't make it work from a regulatory standpoint, and I'm telling you I don't think it's very good policy if in fact those millions of dollars are flowing back to MDU ratepayers in North Dakota, and they are, then this bill tells people not to engage in that kind of a arrangement for their data center, and I don't think that's the direction we want to go. Thank you.
Thank you. Further opponent testimony to Senate Bill 135.
Morning, Mr. Chairman, members of the committee. Ryan Budmeyer, South Dakota Chamber of Commerce and Industry, originally from Belle Fourche, live in Sioux Falls with my wife and 2 kids. We rise in opposition to Senate Bill 135. Really, the only issue we have with this bill is Section 5. There's been a lot of talk about the potential upside of to these companies and to the states in which they locate. None of that matters if we're not in competition for these projects. So we ask you to oppose 135. Thank you.
Further opponent testimony. Senate Bill 135.
Good morning again, Mr. Chair, members of the committee. Mitch Rave with the Greater Sioux Falls Chamber of Commerce, representing 1,800 plus businesses and thousands of South Dakota citizens. We would echo the comments of the previous testifiers in opposition. We do appreciate the intent of the good senator on this bill, but there's a few pieces that we think need some work still. So with that, we'd urge your opposition. Thank you.
Thank you. Further opponent testimony. Senate Bill 135. We're at 8 minutes.
Thank you, Mr. Chairman, members of the committee. Bill Van Camp, a registered lobbyist with the Retailers Association in South Dakota. We do have over 4,000 members in South Dakota right now who are retail businesses. We see this bill, unfortunately, as an anti-economic development act. The definition in Section 2 is incredibly broad and picks up any number of possible businesses. And to say just writ large, we're not going to incentivize anybody that comes into the state in this space, we think is a mistake. Thank you.
Further opponent testimony.
Mr. Chair, members of the committee, my name is Kyle Peters. I'm a representative of Gemini Family Office. We rise in opposition of this. The main sticking point for us is Section 5 of the bill. As I mentioned earlier, we are a development company. We're trying to recruit hyperscalers. Mr. Phillips said it very nicely, so I won't repeat those comments, but we rise in opposition. Thank you.
Thank you. Further opponent testimony.
Mr. Chairman, Aaron Scheibe, Clean Grid Alliance. We would also rise in opposition. In particular, would associate our organization's position with what you heard from Mr. Koenneke and Mr. Van Camp. I think they ably described some of the issues that are facing here. Beyond that, there are some things in here that are potentially good, and I think we'll hear more about that later on today as well. But as it stands now, we would oppose this and ask for you to oppose it as well. Thank you.
Thank you. Further opponent testimony. We're at just about 10 minutes. So
thank you, Mr. Chairman. Steve Del Bianco, CEO of NetChoice, the trade association for America's tech industry. Just two final comments. Our industry fully supports the mandate to pay our own way. We have been and are continuing to do so. So much of this bill is in line with the principles that we embrace. However, Section 5 is a fatal flaw. Section 5 eliminates the ability for South Dakota to treat a data center set of servers and equipment the same way South Dakota treats the equipment and machinery that goes into the farmers and ranchers. Exempting from sales tax is not by any means a subsidy when you're exempting sales tax on the business inputs. There's no transfer of money from the state to the companies, and over 40 states exempt the servers that go into data centers. It's one of the reasons why there are no data centers here. I'll close by saying, Mr. Chairman, our industry is proud of the fact that we are the #1 capital investment industry in the United States for 6 years running. #1, more than pharma, manufacturing, more than any other energy industry. We are #1, and we go to communities that embrace the jobs, the investment, and the property tax relief. So if you want to listen to the people, as a proponent talked about, listen to the people in rural counties that are desperate for six-figure jobs for high school grads, desperate for relief from property taxes that they can scarcely pay for declining infrastructure, and also the small businesses that benefit from the ability to do the construction and maintenance of a data center. Thank you.
Thank you, Mr. Del Bianco. Is there any further opponent testimony to Senate Bill 135? Seeing none in the room, I don't believe there's any online, so we will close opponent testimony and go to rebuttal.
Well, thank you, Mr. Chair, members of the Senate State Affairs Committee. Chris Carr, Senator District 11. You know, when Mr. Bicorny earlier said there was another bill with structure that he liked, I really thought it was mine. I'm devastated here. I'm going to try to recover. Section 2 talks about the definition. This is not my definition. This is the industry's definition. This is what they've chosen to, the words to define a data center. So I really think, these sections, except for Section 5, everybody understands and agrees we've got to protect our utilities, our resources, and our ratepayers. I think Section 3 does a pretty good job of that. I think that there's mechanisms in place with the utilities, the electricity utility providers, to determine and analyze what's happening, increase the fees, who's responsible, and to allocate those costs accordingly. So I think that all exists. If you're, we have the PUC that oversees IOUs, we have the co-ops have boards, the munis have city councils, et cetera. There's wholesalers and providers that can help provide that analysis. So I think that that is a doable task. Why? Let's just talk about the incentive then. You know, this bill, originally, when we worked on this, I worked with a speaker, you know, what I'm hearing from a lot of folks on, it doesn't matter what their political affiliation is, their concerns are about the utilities, their concerns are about us financing or subsidizing or helping to incentivize these companies that are spending billions and trillions of dollars. And why should we protect ourselves? I think there's good reasons why we should protect ourselves. But I also just want to take a minute, and I did a handout. Let's recognize for a second the benefits of South Dakota and what it's like to do business here. We've protected South Dakota and its business landscape. We have no corporate income tax. We have no personal income tax. We have a competitive property tax structure. Historically, we are business-friendly regulatory climate. We're a low-tax environment. This handout gives you an example. We asked LRC this summer to just provide an analysis on a 100-megawatt data center. There's some assumptions here, so I grant you that. But it looked at our neighbors, Minnesota, Iowa, North Dakota, South Dakota, what the power costs are, what the other operating costs are, the total operating costs. So this is just about operations alone. That's all we're looking at with this analysis. And you can see from this that the 10 years of operating costs by state, South Dakota is the lowest. Minnesota is the highest with a $1.8 million. Iowa's second with 1.6, North Dakota 1.4, and South Dakota 1.3. Just thought it's worth noting what South Dakota does have and what we do provide for businesses before we say we're not competitive. There's other factors other than just a sales tax exemption. What this bill does is still allows for other incentives. It still allows for the existing rebate program that's offered through the Governor's Office of Economic Development. It still allows the localities to offer their economic incentives. There was a concern that was also brought up. I just want to point this out. In Section 4, there was a concern about us granting new authority. This bill, nowhere in here grants new authority. That first sentence in Section 4 says the state may not preempt or otherwise limit the authority of the governing body. That's talking about the existing authority. There's no granting new authority. I think that's a real reach. That's spaghetti getting thrown at the wall. Why should we protect ourselves? Because we're talking about our ratepayers, we're talking about our taxpayers' dollars and how we're using them and investing them in a business, an industry where the CEOs of these companies are predicting a major bubble. Do any Google search, and there's some great quotes out there. I'll provide a couple. The IBM CEO, Arvind Krishna, I apologize if I massacred that name, warned there's no way massive multi-trillion-dollar investments in AI data centers will pay off at current infrastructure costs, noting that to cover costs, companies would need to generate hundreds of billions in profit, which is difficult given rapid hardware obsolescence. Alibaba chairman cautioned the current rapid pace of data center construction may exceed immediate demand, warning of potential bubbles due to limited practical, high-revenue consumer-level applications. CEO for OpenAI, CEO for Amazon, CEO for Google have all expressed the irrationality in this market and the trillions of dollars being poured in, and how that return is not realistic. They're saying there is going to be a bubble. There are going to be some losers. We may be one, we don't know, but they still think it's worth investing. I mean, I'll give them that. They're not saying don't invest in data centers. But the point is, there are going to be some losers here. We're talking about an industry that's going to have losers that we're being asked to invest in. I think we need to protect ourselves, and that's all this really aims to do. So I'll stand by for questions. Thank you.
Thank you. Thank you, Senator Carr. We will now open it up to committee questions. Senator Dybert.
Thank you for the prime sponsor, please. Okay. So, Senator Carr, under Section 5, if you have a discretionary formula in that area which defers or reduces property taxes for a certain amount of time, you could no longer use that under this section?
Mr. Chair, thank you. I don't believe that that is what, this is saying no tax exemption for data center. You're talking about a property tax incentive?
Yes, if you have a discretionary formula where they don't have to pay a property tax on their full value or any value for a certain number of years to bring industry in, that would be a tax exemption. So you wouldn't be, according to how I read it, you wouldn't be able to use that discretionary formula.
I'd have to get back to you. I don't want to give you wrong information.
Thank you.
Further questions from the committee? Senator Colbeck.
I got one for Mr. Phillips.
Mr. Chairman, Nick Phillips.
Thank you, Mr. Chairman. So when we're talking about this, Section 5, can you tell me why you haven't already pulled the trigger? Because what this is saying, and I have some disagreement with the prime sponsor, but he's saying that we would just do status quo. We would be able to put protections around water and electricity in this bill, and that we could still do our GOED rebates and all that stuff. So if that was true, why haven't you built in South Dakota yet?
Yeah, the current, Mr. Chairman, the current tool which is available to GOED, the RPP, is inadequate to convince us to come here because there's not certainty that's needed over a long period of time. When we look to build one of these facilities, it's a many billions of dollars of investment in that facility. In order to depreciate that building over a long enough period of time, we look to 30, 50, 100 years for those costs to be recouped. And GOED's current tool allows us for 3 years of exemptions, which is inadequate. So if we compare, I know that the sponsor had talked about something from LRC. I think some of that is actually pretty good, but some of it's not quite there. When you look at the surrounding states, if you compare South Dakota to the surrounding states, it would cost roughly $2 billion more to build one of these facilities in South Dakota as compared to one of those other states in sales tax on all the equipment and everything else that's collected.
So just to follow the 40 other states, even though it's cheaper to do business here, we don't have corporate income tax, we don't have state income tax and stuff, it's still, the delta is more to build in South Dakota.
Mr. Chairman, actually, because of the large energy usage and the state of South Dakota's applying sales tax on energy, it actually becomes not less expensive for all of the other things here. For example, in North Dakota, for a facility that we would estimate there, which has an income tax on corporate income, we would estimate that facility would cost about $8 million per year in income tax to operate that facility. Yet here in South Dakota, we would pay about $10.5 million on average over a 15-year period in sales tax on energy. So you actually wipe out the benefit of the not having an income tax in South Dakota just by the sales tax on energy by itself. And so adding to that the extra $2 billion of extra cost between construction excise tax, contractors excise tax, sales taxes on all of the components of the buildings, plus all the refreshes of the machinery, you can actually never close that gap of that $2 billion because you're actually paying more per year, just on the sales tax on the energy itself. So it's actually more expensive here than in other states.
Thank you.
Senator Jensen.
Thank you for Net Choice. Thank you. Either one of you. Yeah, this has more to do with the, equipment obsolescence and turnover and how many times you have to replace the servers. We're looking at anywhere, we did look at a 50-year exemption. One of the things we're looking at in the future today maybe is a never-ending exemption. Can you give me an average obsolescence? I have an IT background, so I'm pretty familiar with it. But how much equipment would turn over every year? Because I know it's a constant process.
Mr. Chairman, Steve Del Bianco with Net Choice. Thank you for the question, Senator Jensen. In a 3 to 4 year range, almost all of the servers in a data center are replaced. We call it a refresh cycle. And that would be every 3 to 4 years. We replace the servers and the chips that are on the servers. We don't replace the racks, the cooling systems, the power systems, the shell, just the servers. But the servers are 2/3 of the cost of a data center. especially when you have those NVIDIA chips strapped on the sides. So the refresh is done to accommodate chips that run faster, cooler, burn less electricity, and have more advanced ability to satisfy our appetite for using AI. So that is a cycle of 3 to 4 years. It's well established, and it's one of the reasons that our industry looks at states that have a long-term sales tax exemption. Many are permanent. Many are at 50 years. North Dakota's is permanent. But in the case of South Dakota, we have tried to work with proponents here to see if we could get to the 30-year range.
Senator Pischke.
Well, thank you so much, Mr. Chairman. My question is for Mr. Phillips. I apologize for not being here on the previous bills and really want to learn more about this, and so excited to have this discussion today. In your testimony, Mr. Phillips, you made the comment, "We would love to be here." Can you explain why you'd love to be in South Dakota?
Mr. Chairman, Nick Phillips for the record. Senator, there's actually a lot of reasons. I've really grown to enjoy both Dakotas. I've spent a lot of time here for the last several years. In the last year, I've spent a bunch of time going around the state and seeing various things, having conversations with lots of South Dakotans, which I've enjoyed very much. Beyond that, South Dakota is a net exporter of energy. And you can choose to do two things. You can go to where energy is, which is what our company has done. We chose to locate in all of the locations that we're in because there's an abundance of energy there. And the benefit for going to where energy is that you don't have large transmission lines and costs associated with using that. You also find cases in which there's energy that otherwise could not go onto the system that you can utilize. So for example, in Ellendale, North Dakota, we are in the center of within a 100-mile radius of that facility. We are surrounded by 2 gigawatts, so 2,000 megawatts of wind energy. There are times at which the transmission system is unable to carry the large amount of energy that's produced by those wind farms because sometimes it's windy in the Dakotas. And when it is windy in the Dakotas, it produces too much energy. And so we are able to utilize energy that otherwise would not be consumed because it can't go onto the grid. That's good for a variety of reasons. There's some fuel-related reasons that make sense for that. There's economic reasons that make sense for that. So that's helpful. The other reason that South Dakota is attractive to us is it's cold. Normally, you wouldn't invite somebody to come to South Dakota and say, hey, it's cold and windy, please move here. But for us, it's cold and it's windy. The cold helps us in operations in that we can save, we published a white paper on this. We can save about $50 million per year in operational cost per 100 megawatts of IT load as a result of not having to use chillers and other methods of cooling because we can use what we call free cooling that's outside. That allows us to be competitive and attract some of Mr. Del Bianco's members to become customers in a location such as this, which is actually more challenging because we have to work on workforce development and training, and we would like South Dakotans to work at these facilities, but we can attract them because there's some cost savings and operational benefits from being in a cold and windy climate.
Further questions? Senator Perry.
Thank you, Mr. Chair. This will be for the prime sponsor of the bill or his right-arm man there, either one of you two. Mr. Chair. I'm going to go ahead and ask my question, and this is one of those things, Senator Carr, where we say we're going to protect the taxpayers, we're protecting the utility customers, and we're supporting local control and transparency. Those are the things I see in your bill. And why do we have objection?
Thank you. Well, I think most of the objection comes from Section 5. They want more incentive to come to South Dakota. And I'll just say, you know, I don't have a good analysis state by state, but I provided you with our surrounding areas and some of the operating costs, some of the things that are strong about South Dakota. A good question that was just asked too about why South Dakota. South Dakota has strong wind generation, it's competitive electricity rates, expanding transmission infrastructure, cold climate to reduce those costs. We have lower humidity than coastal states. We have lower risk of wildfires, hurricanes, earthquakes. We have abundant and affordable land compared to a lot of the other states in the country. We have minimal zoning friction in many jurisdictions. We have faster permitting environment. And then we have all the regular incentives, no corporate income tax, no personal income tax, competitive property tax structure, as I mentioned. You know, in appropriations, we have bills presented all the time and say, well, why can't we do this more like this state or more like that state? And we can't catch everybody. We can't chase our tail on every single area, in every single area. We're just not built that way. We don't have that, the dollars to do that. And what I'm saying is we need to protect not just the utilities, not just our resources, but our taxpayers' dollars regarding the incentives, the economic incentives that we're going to provide to large businesses, large consumers of our resources. Hope that helps answer your question.
Further questions? Senator Colbeck.
Thank you, Mr. Chair. So traditionally, South Dakota has given, we have about $1.5 billion worth of property or sales exemptions on the line. Why not data centers? I know that you say they have multiple resources and things like that, but traditionally South Dakota has not been a tax-rich state. So why do these bump up into something else that wouldn't qualify?
Well, Mr. Chair, I'm not a big fan of us picking winners or losers, period, in the corporate world. And I think I mentioned that last year on a bill of this topic, you know, working with the Governor's Office of Economic Development to say, you know, I understand that these things exist. And we recognize that with this bill to say there are certain economic incentives that already exist. But I'm not sure that we need to go any further and give away any more of our taxpayer dollars to be attractive to these companies. I know that we have one saying that this is the deal breaker. I think there's plenty of good incentives. I just listed a ton. And I'll mention, you know, there are other states, when I was looking at this, that there are large-scale hyper data centers that don't have some sort of statewide incentive. It's primarily through localized projects and specific deals. And that's what we try to still allow here. And those three states that I found are New Mexico, California, and Colorado. They have major hyperscale data centers in California.
Further questions from the committee? Seeing none, I just have one question very quickly for Commissioner Nelson. And as you're making your way forward, I'll just ask it, so listen up. There was testimony given that South Dakota ratepayers, MDU ratepayers, have enjoyed a $1 million benefit as a result of the data center in Ellendale. Can you confirm that that's the case?
Chris Nelson, Chairman of the Public Utilities Commission. I have not done that calculation, and so I can't confirm that that's the exact number. But what I can tell you, and basic economics tells us this, that when you sell more widgets, you drive down fixed costs per widget. And that certainly would apply in this case also.
Thank you. That is all. So seeing no more questions, we'll close questions and go to committee discussion and or action. Senator Jensen.
I'll move due pass.
Second.
We have a due pass from Senator Jensen, second by Senator Pischke. Any discussion on the motion?
Mr. Chair. Yeah, my number one objection from the very beginning when we started talking about this is the tax exemption, sales tax exemption. We don't afford those exemptions to any other business. I mean, we got our hospital systems, we got, well, maybe that's not a good example, but the banking systems, any others, we don't give those exemptions to any other group. And as was stated, you know, 2/3 of the cost is going to be the servers, and they're going to change over every 3 or 4 years. That's a huge loss to South Dakota that we could have income from that. I find it a little frustrating to compare it to our farmers. The data centers and the people that run them and own them are some of the richest people in the world. Our farmers, who we're so proud of, are some of the poorest people in the state. They struggle every year. They fight through weather. They fight through droughts to put our produce out. And yeah, we give them an exemption because we fully support those farmers as one of our major industries in this state. I think the water use, I think the electrical use is all a little bit subjective. It's a rolling target. We don't really know exactly what it will do, but we know exactly what the sales tax would do. And that's my number one objection, and that's why I think we need to do a pass on this so we can have further discussions on other bills later. Thank you.
Further comments on the motion? Senator Colbeck.
Yeah, I'm going to resist the motion only because of Section 5. Obviously, we can talk about electricity or water, things like that, and most of what's in the bill is already being done. But 0 from 0 is 0. We're not giving taxpayer money away if we don't have it. 0 from 0 is 0, and that's just it. If they're not here, they don't get it. What we are losing is the other residual. We're losing the property tax. We're losing the sales tax on electricity. We're losing the contractor's excise tax. That's the tax we're losing. So, in my opinion, and with the good senator brings a good point. We're not comparing this to farmers, and we shouldn't. But the reason we have that $1.5 billion in tax exemptions is because those are input costs. That's why we don't tax advertising. That's why we don't tax feed, diesel fuel, all that stuff, because that's an input cost into a business. And that's what they're asking here. If we don't give a tax incentive, that's an input cost. Those servers are their input costs. So that's how I see it in my mind. So if Section 5 was in there, it'd probably be a better bill.
Further comments? Senator Carr.
Thank you. Thank you, Mr. Chair. I appreciate the comments, the concerns. I like that I think we basically all agree we need to protect and make sure our ratepayers and our resources are protected. I've heard good testimony saying not only are we not going to drive up costs, we're going to reduce costs. That's great. I love that. This just ensures that it doesn't go the other way. Regarding the incentive, I think here's where we're at. I think there's a scale of how much economic incentive you're comfortable with in these situations and providing. We have a lot of economic incentives already. I can list all the great things about South Dakota and why you should be here and why you should build these things here. But we also already have a program through the Governor's Office of Economic Development that can provide that sales tax rebate and those dollars back, and they get to judge it case by case. So that process exists, and that's there. And this is where my comfort level is based on my conversations, and I think it's a good compromise of saying between no tax incentives, no economic incentives, I should say, and here are some that you can still use.
Thank you, Mr. Chair. I'd like to add a few comments. Well, I do appreciate the discussion. I appreciate the fine gentleman here talking about our cold and windy climate here. I too appreciate our cold and windy climate as a sportsman, a deer hunter, a outdoorsman, duck hunter. I like the cold and windy too. So, and thank you for being interested in being here for those factors. We just heard on the floor yesterday about how we have bills to pay here in South Dakota. We have our state employees, we have our teachers, we have our community support providers, and when we're providing this tax exemption, we're not generating that revenue to pay for those bills. We as a state, we have bills to pay. I don't want to sound like a big government politician up here, but the fact of the matter is we do have obligations that the state has to make. And so I'm not opposed to data centers. I think that they're interesting. I mean, there might be some health concerns, yes, and I think we can alleviate that with all the other things in this bill and the setbacks and whatnot. But I just think that they should pay their fair way. So that's why I second the motion. Thank you.
Seeing no other comments, I'll just make a few of my own. First off, we do offer a ton of tax exemptions, and I would also point out that Bill Gates is one of the largest owners of agricultural property in the nation. And right here in District 24, probably one of the largest owners of ag property is Ted Turner. And he is the beneficiary of a lot of the tax exemptions that we offer here in South Dakota. I don't have a problem with that because those exemptions are there for a purpose, to incentivize agriculture. I think that's a good thing. With respects to data centers, I like to quote talented people. I'm going to quote Billy Preston: "Nothing from nothing is nothing." And you're going to have nothing if we maintain the status quo with our attitude towards economic development in this state. I think we're seeing North Dakota, we're seeing Iowa, we're seeing all the states all around us that do offer these incentives are reaping the benefits, and we're left twisting in the wind. So for those reasons, I am going to resist the motion. With that, I will ask the secretary to please call the roll.
Senator Dybert.
No.
Jensen.
Aye.
Carr.
Aye.
Colbeck.
No.
Larson. Pischke.
Aye.
Voigt.
Aye.
Perry.
Aye.
Melhoff.
No.
Mr. Chairman, we have 5 ayes, 4 nays.
Senate Bill 135, having received a majority of the votes, will go to the floor with a due pass motion. And with that, we still have one item on our agenda, but we are going to waive that to the afternoon session that we have planned after session closes. And with that, I'll look for a motion to adjourn.
So moved.
Motion by Perry, second by Pischke. All in favor say aye. Aye. Motion passed.
SDPB shares the voices and experiences of South Dakotans, preserving our stories, our culture, and our sense of place. SDPB, good, useful, and full of wonder. As South Dakota's public media network, SDPB serves everyone with transparency, integrity, and commitment to open access. Good, useful, and full of wonder. SDPB. SDPB helps shape South Dakota's future by educating, informing, and inspiring the next generation of thinkers, leaders, and creators. SDPB. Good, useful, and full of wonder. SDPB serves South Dakota through an interconnected communication system that is on 24/7, 365. The first place for Amber Alerts, public safety announcements, and EAS messages. SDPB keeps public servants and citizens informed. Good, useful, and full of wonder. SDPB. SDPB brings you closer to your government. With gavel-to-gavel coverage of the South Dakota Legislature and in-depth reporting from peer. Good, useful, and full of wonder. SDPB. From early learners to lifelong students, SDPB inspires curiosity through trusted educational programs and resources for every stage of life. Good, useful, and full of wonder. SDPB. When South Dakotans need reliable information, SDPB is there providing updates and coverage that keep our communities safe and connected. Good, useful, and full of wonder. SDPB.